పేపర్లో కొట్టి అది మూడుగా నాకు మూడు మేడం ఒకటి పోస్టింగ్ ఫర్ ఎగ్జాంపుల్ 55 I'm reading on this. Thank you very much.
Silent.
Sixth. She's sitting just right in front of him. She's comfortable.
Yes. Page wise mentioning, page number 1, item number 1 to 3. Page number 2, item number 4 to 16.
Item number 15. Item number 15, my lord. I am counsel for the petitioner. The first respondent has to file counter. Lodge may post after 1 week, my lord. Item number 15. After 1 week, any date may be given.
So I said 16th.
15, 1-5.
16.
Much obliged.
Yes. Item number. Page number 3, item number 17 to 34.
Item number 31 to 34. We take up 2 weeks.
There is some urgency in the matter, my lord. If it can be taken on 9th or 10th, it's covered. They said they have a senior advocate appearing.
Yes.
There is a very great urgency in the matter. It can be heard in 15 minutes, my lord. 9th or 10th, it's covered.
Holidays for them. Only request.
No, it's like this. If a council opposes, I cannot give a long adjournment. Yes, Randy.
May I please, my lordship?
9th or 10th, 31, when the motion is.
WP 17056 of 20, my lord. It was
Yes.
posted for orders,
Yes,
but it was not listed on 311, my lord. Maybe posted like tomorrow.
yes. What is the number? Repeat the number.
17056 of 20.
Yes. Verify and list on 9th.
Much obliged, ma'am.
Yes. Start from here. Yes.
Just complete one pay one. Page number 4, item number 35 to 49.
Tomorrow? 7 to 39 at the request of the council for the petition. List to me.
My ladyship, I don't have a problem with matters taken up tomorrow. Actually, on the previous day that I was the one.
Just wait a second. Just wait a second. Please type in the. Just wait.
Page number 5, item number 50 to 52.
Yes, this one. Verify and list on 9th. Yes. Yes, hand over to the court officer. Yes, verify. Yes, verify and list on 10th. Yes.
Tomorrow 2:30. There is urgency, but serious situation.
Not 2:30. It will come in the list. I don't do that, children.
Tomorrow.
Yes.
Pressure of OU, contested elections will out, and the election nominations will be filed on November 10th. So there is a urgency.
Yes, verify and list on 9th. Yes.
Because the petition is an 85-year-old lady, madam.
Yes. Verify and list on 9th.
District education officer has shut down the school, my lords, and heard the matter, my lords, and posted for instructions to the motion was not listed.
Yes, verify and list tomorrow.
Petition matter cantonment was.
Yes, verify and list on 10th.
Occupied matter will rise.
Yes, 1 second. Yes.
Your Honor, this book is that the urgency is that Your Honor, tomorrow for the exam.
It's 2:30. Yes. Shouldn't. Verify and list tomorrow. Yes.
Occupied matter meant right to application will not be listed.
Yes, verify and list on 9th. Yes.
Great inspector, CC number 784, review the 23 and the tax with this handbook report was basic to directly listed today, but those have not been listed due to non-compliance of the orders of the respondents have not
Yes.
taken this tariff.
Yes, we'll list it on 10th, Friday. Yes, all the matters on 5th.
At 9th, maybe personal convenience.
Yes. Contempts are usually on Friday, is it not? Yes, 10th. Yes.
18 October, but due to positive time, the matter did not come up for hearing.
Yes.
The urgency petitioner bank has been given without any document.
Yes, tomorrow. Yes.
Connected by.
But this petition was they must have that state and same director response not to proceed with the management of state of the data shape of one location.
Yes.
So state has to be extended because taken up today to that's.
Yes, 2:30.
Connected matters are listed serial number 41 to 43. Okay. 2 times we moved a letter to the district also. Maybe they can have 230 also.
Not 2:30, tomorrow.
Is already
Yes, tomorrow. Yes. Hand over the copy of the letter. Yes.
Okay, cancellation of admission, but I read my 2 times letters to the district.
Yes. Yes, verify and list tomorrow.
We have given a request, but I came from Bangalore logic. Maybe consider 230. Connected matters are there.
Tomorrow. Yes.
Those 17 matters, some of them inspect, become inspector, some of them.
Yes, hand over to the court officer. Yes.
Taking disclosure, next week we get it.
Yes.
5 matters are there.
Verify and list on 10th.
5 matters.
Yes.
Much of them. 300 matters.
Yes. Yes, sir. This. Yes, verify and list on 9th court officer. This one. Yes.
Your Worship, petition number 83844, 2022. The respondents are dragging the matter for one petitioner to another.
Yes.
Since last 2017, before the holidays, it was listed.
Yes, and hand over to the court. Yes, 14th. Yes. List on 14th. Yes.
So if I saw, with respect to draining of sewage water into petitioner's land, which is considered by the
Yes, 14th, yes,
already under the
yes.
Ships currently we don't think that, but it's to termination of a dealership. Already see those reports is organized. Coming up for once. Several that was given in.
List on 9th.
For 9th, we know.
I said list on 9th.
Portfolio matters, CRP last time.
Yes, Friday. List on 10th. Yes, doesn't matter. We'll consider 10th. Yes.
Submission. The matter pertaining to obtain a consent something for construction of their house permission, we have given a letter to.
Yes, list tomorrow. Yes. Yes.
This is with respect to item numbers 37 to 39, which is mentioned by the petitioner.
Yes.
Seeking an adjournment for tomorrow because of the unavailability of their counsel. I was mentioning my lady that I don't have a difficulty with the matter to be taken up tomorrow. It's just that on the last day of hearing, I was the one who mentioned that let the matter be fixed for Tuesday. But instead, the council had insisted for Monday, and now in the morning they wanted.
But you started your representation saying that there is no difficulty for you to be here tomorrow. Yes. Tomorrow without fail, make your arrangements. Yes. Call the list now.
In fact, it can be.
Yes, it will come. I'll complete the entire list. No worry. Yes.
Page number 1, item number 1, CSU Law Office, G. Praveen Kumar, Deputy Solicitor General of India.
May I please, my lords? My lords, I'm representing the advocate on record for the writ petitioner, my lords.
Yes.
Fresh matter.
My lords, the proceedings are under Public Premises Act, my lord, wherein the third respondent had passed an order of eviction of the petitioner from the premises, contending that it's a public premises, and the order passed by the third respondent would come at page number 56, my lords. My lord, the order is dated 16th March 2018. In which the third respondent contends that a show cause notice was caused to the writ petitioner, and that's being replied. That the show cause notice says that the property which is occupied by this writ petitioner is a public park to an extent of 130.75 square meters. However, the petitioner constructed a house in an extent of 256 square yards, but then the property was acquired by the writ petitioner way back in the year 1990 and a registered sale deed from the society, and then constructed house over it, which is being equipped with all amenities like electricity, water supply, etc. And it is under the enjoyment of this writ petitioner. However, the notice was caused by the third respondent, contending this is part of public park. Therefore, it is being encroached by the writ petition, sought to be evicted from the premises by issuing notice under Section 4. But consequently, the writ petitioner appeared and made his submissions, and on which the third respondent passed orders on page 56, which comes at page 56. The contention of response number 3 is that I have encroached into public park and therefore not entitled. In the public park, it has become public park because the property is vested with the third respondent cantonment board by virtue of section 122F of Cantonment Act. Now, they agreed by the eviction order, the writ petition preferred appeal before the Chief Judge City Civil Court Hyderabad, and appeal was heard at length by the Chief Judge Hyderabad and passed orders, which comes at page number 19. The appeal preferred by the writ petitioner was also dismissed on the ground that the premises which is occupied by the writ petitioner is a water tank, not the public park, it's a water tank. So there are two conflicting statements made by the respondents. At one point, it is being contended as the public park is being encroached partly, and at the second point, they said that it is water tank, which is according to their own counter affidavit. The counter affidavit which is filed by the respondent would come at page number 68, my lords.
Yes.
In this counter, the contention of respondent would start from paragraph number 3, page 69, my lords, running. Paragraph number 3, clause 1, which runs up to page 70 also. Now, there it was said in the last line of page 69. The area earmarked for overhead tank of the said layout is vested in Secunderabad Cantonment Board as an absolute owner under section 122F for the Cantonments Act 2006. Therefore, it is contended by the board that this property is vested with the board pursuant to section 122F. 122F of the Act says that the property which is vested with the Cantonment Board shall be by virtue of an execution may take for a movement by law to section 122F, where it says all lands, well, I'm going to section 122F directly. F says the property should be transferred by the individuals in favor of cantonment board by virtue of a registered instrument. Unfortunately, no such document is being produced by the cantonment board to say that this property is transferred by the layout makers in favor of cantonment board. That is how the cantonment board successfully failed to demonstrate the property is vested with the cantonment board. In the absence of any title to the cantonment board, that can't be referred as public premises as contained under section 2 of Public Premises Act. Now, the property is not vested with the cantonment board and the property is never to be termed as public premises, but invoking the provision of Public Premises Act itself is bad in law. But that is being contained continuously. That the orders passed by the third respondent is eviction. That there is substantial question to be adjudicated to say that whether the property is vested with the cantonment board or not by virtue of a document that is to be asserted. Whereas 122F says that all lands, other property transferred to the board by the central or state government or by a gift, purchase or otherwise for local public purpose. So the property shall be vested with the cantonment board only under this procedure. If the procedure is not that nothing has been transferred to cantonment board, it is not the property of cantonment board. If it is not the property of cantonment board, invoking section 4 or 5 under Public Premises Act itself is bad. So therefore, that point has to be asserted whether this property belongs to cantonment board or whether the cantonment board is competent enough to invoke Public Premises Act is the question of question for consideration. Till then, let the impugned orders have to be suspended because I have been occupied for the last 3.5 decades. For the last since from 1990, I'm in physical possession of this property, and they say my premise is partly into public park at this juncture.
Yes, who appears for the cantonment board?
Passover?
My lords, I couldn't hear the counsel for cantonment bid as she was not using the mic. My lords, I beg pardon, my lord.
This is only Passover.
Fast.
Yes.
Obliged. Obliged.
We'll consider at 2:30.
Obliged.
Item number 2, B. Ravindra Babu, G. Praveen Kumar, Deputy Solicitor General of India.
Which matter?
Whereby he, who is a nominee director, was declared as the Input Department. See that page 25, page 25 is the extract from the MCA website, that's form 32. Last week I can see appointment for the designation, nominee director. The name of the petitioner is Sridhar Charan.
Yes.
He is the petitioner, he is a nominee director in that particular. Plus, he was declared as a Input Department by the Input Department screening committee. Last week I can see the circular issued by the RBI dated 1/7/2003. Is a page. The relevant portion is at page 147 and 148. Last week I can see page 147. There, the mechanism for identification of Input Departments is detailed. The last week I can turn to page 148 D, class D. Class D is the relevant for this aspect. As regards a non-promoter, non-head director, it should be kept in mind that section 2, subsection 60 of the Companies Act defines an officer who is in default to mean only the following categories of directors. One, full-time director. 2, where there is no key related person, such director or directors, as specified by the board in this behalf, and who has or have given his or their consent in writing to the board such specification, or all the directors, no directors was specified. Every director, in respect of a contravention of any provisions of Companies Act, is aware of such contravention by virtue of the receipt by him of any proceedings of the board or participation in such proceedings, and we are not objected to the same, or where such contravention has not taken place, is consent of the members. Next paragraph. Therefore, except in very rare cases, a non-full-time director should not be considered as a full department unless it is conclusively established that he was aware of the fact required by the board by virtue of any proceedings regarding in the minutes of meeting of the board or a committee of the board and has not regarded his objection to the same in the minutes or the willful default had taken place with his consent or connivance. It is not their case that willful default has taken place with my connivance or consent. It is not their case. I am, by virtue of the proceedings recorded in any of the minutes of the board meetings, that I am responsible for the willful. The willful default was committed by the company. I am only a nominal director. This explanation was given to the show cause notice given by the committee, and that explanation was not considered. They have given a notice of personal hearing. I have expressed my inability to attend before the personal hearing on the ground of ill health, enclosing nearly 20 medical reports.
Yes.
They did not consider.
Who appears for the respondent bank?
Apart from that, they did not pass an order. They have communicated only the decision of the willful default.
You take out personal notice, we'll consider. Yes, ma'am. You take out personal notice.
Page 205, one moment. Page 205. Same I could grant it suspension of the order for the same petition. And the same proceedings were initiated by another bank. The kind is the page 203, 203 and 205. That's also extended. Similar circumstances, same petition that was initiated by Union of India and Indian Bank. This is by Indian Bank. Same committee law. Each bank has a committee. Every bank is going on initiating these proceedings, and he has filed a similar writ petition on the same grounds that was considered. That was argued before the Honorable Court. Exactly two subsection 60 of the Companies Act was argued. Last week, anticipation order. Let's go on.
Limited stay. Yes.
Item number 3, P. Lakshma Reddy, G. Praveen Kumar, Deputy Solicitor General of India.
And here they are taking particular steps and seized items. So that is an expression of the responsibility.
Request is for a passover. Is password 230? Along with item number 40, along with that. Yes.
Page number 2, item number 4, A. Srinivas, G. Vijay Kumar, A. Prabhakar Rao.
This is coming for discussion.
Yes.
Yes. What it is for the absence of plastic?
You appear for the?
Negative preparation.
Yes.
First petition is sure. So coming a little college, name of the second petition. They registered on the company's. Year 2001, permission was granted for the 2003-2004 academic. Permission was granted to commence the medical college with 100 students. They were taken, but for the subsequent academic years, there were no permission. But these people completed the 4-year degree course because to complete their internship, they could not do it. Therefore, they were transferred to Harvard College. After 4.5 years. Therefore, the seat was collected from the students across space. But out of that, last semester,
Counter replacement.
detained by the government on the ground, and they completed the course from their college. Page 189. The objection is twofold. One is that their contention that they completed the one semester in their college not sustainable because, as Worship knows, there can't be transfer of students. That has been repeatedly held to be bad by the medical council of India, and it has not been permitted. In this case, also, here again, it is not permitted. I take your worship to the doctor. Page 54 for me. The order begins at page 47. Page 47, shading circle. How they were easily transferred. Christian Medical College, Vijayawada, Andhra Pradesh, proposing for relocation and shifting of 89 MBBS students to other government medical colleges in Andhra Pradesh. Page 54.
Yes.
Supposed to shift these 89 students. Supposed to shift these 89 students to the existing 10 government medical colleges of Andhra Pradesh. As shown, they will correspond to section of seats in the college during the year 2000. Then we go to page 54 bottom. The members of the executive committee and ad hoc committee appointed by the honorable superintendent observed that the batch of students admitted in the college in the year 2003-4 upon the grant of permission to section 10A of the Act, now on the verge of appearing in their final MBBS examination. They therefore at this stage do not require any further teaching and training for the final year of the MBBS course. Since they do not require any further teaching and training as they are scheduled to appear for final MBBS examination, November, December 2007. In these circumstances, there would be a necessary for requirement now at this stage. Shift them to any other medical college only for the purpose of allowing them to appear in third MBBS Part 2 examination of Dr. India Institute from a recognized medical college. On their completion of 4.5 years teaching and training in the MBBS course, and upon qualifying the final MBBS examination November, December, they will be able to undergo rotary internship for 12 months in any teaching medical hospital. Thus, it become necessary for the distribution allocation different teaching medical hospitals for the undertake 12 months rotary internship. When these students of 2003-4 batch scheduled to appear in final MBBS examination November, December 2007 are required to be shifted at this stage to any other recognized medical college only for the purpose of allowing them to appear in third MBBS Part 2 examination. It would also not be in the interest of anyone in this fact, it is contrary to the interest of those 92 students in the state of AP who are going to become eligible for admission in MBBS course for academic session 2008-9 to get deprived of precious MBBS seats in the state medical college. And when, as observed below, no adjustment is needed. Acquired the students of 2003-4 batch are appeared in the final MBBS examination November, December 2007. Ultimately, accordingly, last paragraph. Accordingly, as regard to the above, the members of the ad hoc committee appointed by the Honorable Supreme Court of India and the executive committee of council decided that the 89 students admitted in the applicant college in the year academic year 2003-4
We have almost completed teaching and training of 4.5 years and are scheduled to appear in the examination. In November, December 2007, we transferred to a recognized medical college as proposed by the state government of Andhra Pradesh without any adjustment or reduction of seats in government medical college in 2008-9, as there is neither any logic nor any rationality or justification in any adjustment of these students. As proposed in the state, and further deploying meritorious students of the state of AP have a chance to those members of wishes MBBS seats in a government medical college that state for academic year 2008-9. Further decided to recommend to the central government permit the council to invoke the performance ban guarantee provided to the Government Medical College and make funds available to the state government of every as requested by the state government of the Now this is how these 89 students were shifted. In regard to the scheme, we have challenged the invocation of bank guarantee also. At page 57. They pay 71. They including the fees which is not paid was.
Yes.
Paragraph, for a moment, you have look at paragraph 17 and page 17. 70. Take it complete reading. The first petition invested rupees 30 crore in entire infrastructure lying idle. It is not the case that there is no necessity of establishing medical college area. As there was genuine necessity of establishing a medical college example, the questions have invested rupees 30 crore of permission granted for the intake capacity of 100 students. In fact, 89 students were admitted. Though the permission was not granted for the subsequent years of admission students, all the 89 students admitted in the academy studied in the very same college for 5.5 years and have written their examination without any hindrance. The system shows the second petition college was happy subsequent infrastructure of the to provide medical education to students. Though there might have been some difficulties which are important but not fully as required by MCA. That does not mean second petition college has invested in this category course, which 89 students completed in 5.5 years course in the college. Cannot provide the infrastructure to the students within the college. Therefore, the essentials will not be cancelled. Under the circumstances, the agreement appropriate before of the question. The questions are directed to make appropriate applications taking inspection before MCA. That part will be the impute GOMS and 333 dated 16/2007 directed to keep the events to the MCA re-inspects in second question college takes up first issues as to grant permission for admitted students. In the meanwhile, this third part is direction important for us. In the meanwhile, the questions are liberty to make an application before NTR Ministry of Sciences for refund of the fees collected by it, that is 5 lakhs in so far as C category students. That's fixed by the government in so far as A and B categories at that point of time. Since the students have pursued their entire education secondary education, said application shall be considered by the NTR University of Health Sciences within a period of 4 weeks from the date of visit of the said application. In so far as bank guarantee furnished by the second professional college shall already be invoked by the state, the same shall be recommended by the CI on the question for issuing a bank guarantee. Now, after this, there have to be made a detailed representation. Case number. What was passed? Then the last year's fees alone retained by the government. The balance was returned to us. The balance was returned to us. We are agreed by that portion. We have filed for the equation.
This portion at page 72(4) is not complied with according to you? 72(4) has not been complied with?
It's complied. 4 is what they have it's re-inspected against rejection. We are not, this request is not considered. That's a subject matter. We are only concerned with clause 3. But direction 3, they have considered. And out of the amount so collected, they have retained now 2 crores 7 lakhs 54,000. Which was collected from the 89 students on the ground that they have departed the last year, final year studies. So that will not hold good for students as I have read. They were dedicated to that only for the purpose of writing their exams. So far as examination fees is concerned, they are entitled, but not the tuition fees. This is towards the tuition fees they have collected. Earlier university was the.
Is who appears for the respondent? Yes, 14.
College is originally established at 2003 to 4 and for lack of essential certificate, the NMC has proposed and it is not recognized by the NMC. And by the then government of Bangladesh has not issued a GO. Kindly see for movement page 46.
Yes.
This is operated portion may read it page 48.
Page
48.
Yes.
Taking into consideration the reply given by the management of the college and report of the registrar of the relevant documents and advice tendered by the NCI and the QIC and the subject government have come to conclusion that management of the college have failed to abide by the establishment of medical college regulations and they have failed to fulfill the conditions prescribed in the essential certificate issued to them for starting the MBBS course at college, whereby the academic career of the only batch of MBBS course at college, MBBS students are treated in year 2003 and 4 in the college jeopardized and thus taking over the responsibility of these candidates and shifting them to other government medical colleges has become inevitable, and in order to shift the students to the other government medical college, the state government hereby cancels the essentially certificate issue to the measures for Nizamabad and request the GO5 to invoke the bank guarantees of some amount provided by the college in order to augment infrastructure facilities in the government medical where students have to be shifted. In fact, not out of 100 students intake of capacity, 89 students were shifted to various government colleges. There are regulations formulated by the National Medical Commission, then Medical Council, where the first professional completes the course, then only he will be eligible in second professional, that is second level. Where candidate to clear all the first year, second year, then only he will be eligible in third year. In third year, if he completed all the courses, then only he will be final MBBS and he will be allowed to internship. There are a number of candidates who could not complete the course by that time. So they will not be eligible for internship. These facts will for a moment my counter grant page 154.
Yes.
Relevant question page 152. Para 7. Para 7. Fourth line from top. The university has addressed a letter. Para 7.
Yes.
Para 7 and fourth line from The university has addressed a letter dated 18/4/2009 intimating the petitioner an amount of 18 lakhs 95,000 was collected by the respective colleges, where the students were shifted and aid amount was remitted to the university. In the said letter, mistakenly, it was stated that 34 lakhs to be paid to the petitioner college towards tuition fees due to up to 4th-year MBBS course. It has to be read as set fees for the 5th-year MBBS course, which is 34 lakhs also was paid to the petitioners by way of check dated 21/4/2000. It is also intimated to the petitioner college white letter dated 21/4/2009 an amount of 25 lakhs which was collected by the petitioner college towards internship fees, and the portion deposit will be deducted at the time of making final payment. The university has addressed a letter 10/12/2001 to the petitioner that the university is only responsible for collection of tuition fees from the students pertaining to 5th year, and the management is at liberty to collect the fees from the student of the 4th year. The university has collected rupees 1,59 lakhs also from the students of the petition college, and above 12 lakhs and odd is still due from the students, out of which the petition college is entitled to 48 lakhs and so on. So the petition college was already paid some of the fees, 34 lakhs by way of check, and the petitioner is college is due and payable an amount of 25 lakhs towards internship fees and the portion deposit to the university. Thus, total amount of 59 lakhs and 55,000. Still, the university is entitled to collect 11 lakhs 11,500. The particulars of fees collected from the students and amount paid to the petitioner college, amounts due from the petitioner's college are furnished herewith for the provision of this report as stated such law. Out of 18 students shifted from the petitioner's college, 26 students were admitted into 3rd MBBS Part 1 course, and 63 students were admitted into final MBBS Part 2 course. Therefore, the petitioners are not justified to claim that they are entitled to the fees collected by the university on the premise that they have completed the entire course of study in both teaching and training. Out of 18 students, 50 students are A category students, and the fees payable by them 55,000 per year. 70 students are B category students, and the fees payable by them is 2 lakhs. 20 students are C category students, and the fees payable by them is 5 lakhs per annum. The university has addressed a letter to petitioners 10/12/2012 informing that all the principals of government colleges where the students were admitted to intimate the students to pay directly to the petitioner's college of the 4th year and collect year tuition fees and remit the same to the university. The collection of the fees from the students shifted from the petitioner college was placed before the executive council meeting held on 4/6/2004. The council resolved that after adjusting the amount paid to the college, also amount to be recovered from the petitioner's college towards internship fees and partial deposit to collect some of the fees 11 lakhs from the petitioner's college. The university addressed a letter to 1/8/2013 to the petitioner demanding to pay 11 lakhs 11,500 to the university. The contention of the petitioner that the university has collected 1 crore 90 lakhs from the student is not correct. The contention of the petitioner that an amount of 2 crores and odd after adjusting the internship fees and the partial refunded to the petitioner is not correct. The university has not collected the fees set out in paragraph 13 of the approved. The university has collected only 1 crore 59 lakhs 26,000, out of which 1 crore 10 lakhs 98,000 was to be paid to the college where the students were admitted. In reply to paragraph 14 of the it is submitted that the university wide letter dated 11/9/2012 to the petition based on the resolution of EC Council 29/5/2012 intimating the petition that 26 students out of 18 students who shifted to government college completed more than 1 year period in government medical colleges, and the remaining 62 students have studied 3rd year MBBS courses for 6 to 9 months. The fees collected from 16 students who studies 6 to 9 months course, 50% of fees will be paid to the petition college and remaining 50% fees will be paid to the respective government college. And the details of the fees collected by the respective colleges from the students also are mentioned in the said letter. The extension of the course of study of Indian students who grant from different college was not based on the request of those students. Since they did not complete the course of study as per the MCA regulations, they were not allowed to write exam, which is standard. Not they continue the course till the conduct of supplemental examination September 2008. There is a due from the British administration at 11 lakhs and 11,000 a half.
How do you explain your own letters 11th September 2008, 10th December 2012, 8th January 2013, 12th March 2013?
To that extent, I stated in paragraph 153. University addressed the letter to 10/12/2012. Thereafter, the communication is letter on letter.
Yes.
But first blood did not comply blood the request made by the university. There is due blood 11 lakhs and 11,000 a half from the institutions. Then pay blood the due amount blood who collected from the students. Then only blood it will be concluded how they are entitled and how they are not entitled and for which amount they are entitled and for which amount they are not entitled. If they pay the blood the balance amount 11 lakhs a lot. Because it depends on the duration of the students who completed the courses.
Yes. Who appears? He has been appointed subsequent.
The contention that they have departed education from the pioneers is not good. The whole thing is illegal. That's what they said. Not open to that.
Blood, once the students are shifted blood from closer of college to other colleges.
That's what I
They are not supposed to directly blood to collect the fees from the students. There is a communication to the blood, the government, to the principals of concerned colleges. And I find the copies of that. So illegal.
Institution is not given the amounts. What we are saying is the amounts lying with you collected from the students should be passed on.
For internship, they are supposed to collect the fees from the college students.
Internship they are entitled to, that's a separate issue.
That is only the issue involved with regard to 11 lakhs and all.
In fact, what I have read to your options, the proceedings of the MCA at that time. Page 55. Transfer the limited.
Page 55.
Yes, page 55. Reading circle, please begin at page 47, but it may not be relevant, but has to be page 55. First correction. Therefore, this stage do not require any further teaching and training for the final year of the MBBS course. Since they do not require any further teaching and training as they are scheduled, otherwise they could not have any transfer, because what happens is for the corresponding year again they have to reduce the number of seats. It do not like their mouth to say that we have imparted education. It's their own, it is their. Otherwise, it would require a reduction in intake of the students for this corresponding year. That's what MCA said. Don't do it. They have already completed.
Saying this sense, there is no essence of this.
That is true.
And it is not permitted by the MCA. So for the sake of the academic interest of the students, it is just necessary to transfer the students. In fact, the students, the seats were allotted to students, B category and C category for originally for self-financing policies.
That also we submitted a presentation. This contains all the details.
Page.
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 Okay. 127.
From 14 to 130.
Page 127. 127 is 3rd October.
3rd October 2012.
Consider this representation without reference to those letters. Is rent opportunity without reference to these letters.
And communicate.
Yes.
Lordship decided where the representation is not considered as a PA, then the first.
This particular representation has not been considered. I'm only confined to 3rd October 2012, and he'll be permitted an opportunity. And in accordance to law, you will consider the same and communicate to him.
But 3rd October is already communicated, already considered.
Considered and communicated?
Yes. College to pay the balance.
What is the decision? Or you give a representation afresh within 2 weeks? Yes. Yes, the petitioner is directed to explain his grievance through a detailed representation pertaining to petitioner's request for payment of Prasad, Naresh Kumar Reddy.
Copy.
Within 2 weeks from on receipt of the same. Petition making a representation within 2 weeks from on receipt of the same. The respondent university shall consider the same in 3 weeks thereafter. Confirm to
Item number 5, P. Bhaktapachal, KGK Prasad, P. Naresh Kumar Reddy.
For representation.
this friend. No representation on behalf of the petitioner when the case is called. Post for dismissal again on 9th November.
Item number 6, Syed Ali Murtaza, G. Praveen Kumar, Deputy Solicitor General of India.
Representation.
On behalf of the petitioner when the case is called on 17th October 2023, though the matter is listed and the caption for dismissal 30th October 2023, and again on 6th November 2023, yet there is no representation. And the case is called. The petitioner approached the court seeking claims as a so the issue pertains to law 2014. It is
Item number 7, MT Gauri, GP for Revenue, D. Narsimlu, GP for Home,
Cause of action survives. Look into the papers. Yes, pending. Does not keep it pending. Construction pertaining to the year 2014 is. You're appearing for the 9th respondent. Yes, what are your instructions? Yes. What happened thereafter? Yes. Yes, we'll say that you never interfered and close it. Yes, Randy. No representation on behalf of the petitioner when the case is filed. The petitioner approached.
Item number 8, P. Ravikant, G.R. Koteshwar Rao, Y.B. Ravi Prasad, GP for Revenue.
Yes.
Item number 9, A. Sanjeev Kumar, SC for JNU and FAU. Even today.
Is who appears on behalf of the respondent? Declaration of the results pertaining to the year 2014. Declaration of result AGP for education. Not here. AV, Mr. AV and Reddy. KVN ready. Representation on behalf of the petitioner and the
Item number 10, P. Venkat Rao, GP for Education.
But also not represented. Okay.
Item number 11, Muhammad Azhar, GP for Education, GP for Forest.
Relocation, your lordship said directed.
yes, yes.
Nothing about you.
Okay.
Yes. Yes. Have you given a copy to the learned counsel? Page. You have not said anything. You have not said anything insofar as permitting them to attend the classes.
See the regulation.
Your instructions, your instructions did not speak about the word permitting to.
I was asked regarding this, because they are not provided. I orally asked them, so they stated that there are no objection even allowing, because it is a registration procedure. They want to, they do not want to, don't want to allow him masters because it is by the.
When you are willing and permitting them to attend the classes, then why did you pass an order of rustication? Why did you pass orders of rustications to the student?
Page, this is the regulations. 11 provides the regulations governing Telangana is updated to this university.
Yes.
Unfair means it's a very unfair means it's a MSc PhD student for using unfair means the examination should be withdrawn from the university.
According
This provision in no inquiry is pending. Preliminary stage issued the orders to even issued order provided still until further that. Now we are taking steps to conduct the inquiry within conclude the inquiry. Because it is the prestigious
this.
Petitioners are PhD students, not the inter or 10th class students. Very mature. Even the malpractice also with regard to TPSC examinations. Even if it is not concerned with the academic, malpractice have been taken after pending prima facie has been registered and they have been sent for judicial remand. And then you pass this order pending further orders. Now the authorities want to conclude the inquiry by giving opportunity to them. They will participate in that because only to maintain discipline in the university because it's the residential post they have to, even though it is not academic post but they have involved in the markets of TSHC how it's market of markets subject to the cancelling of TPSC examinations also. Because the students are not the intermediate of the students, they are pursuing PhD post. That is my submission. Lordship may allow the authorities to conduct inquiry. Please conclude within 1 month.
You don't want to say that I have been involved, I have been involved. Till today, competent court of law has to decide it is an allegation that I have been involved, that too on a confession of a 4 accused. Till date, no charge sheet has been filed. Well, just because I am alleged to be involved in a crime does not take away my substantial right of education. That is the even in the instruction, all of this is an afterthought. They had 4 months at their disposal if purported to be true. They had 4 months to do all of this procedure. Now they are saying we'll collect papers. They are not saying we have papers, we will take decision. They are saying we will collect papers of the jail authorities. We will write letters to ACP, concerned ACP. We will get the documents and then we'll decide in 1 month. But that is entirely illegal. After spending 4 months and sitting on it, they cannot say at this juncture that is the second ground that I am raising. And the third ground is that unfair means here they use the words discipline and unfair means. These words are to be interpreted in the context of the academics, in the context of the campus. It cannot mean that some other conduct unrelated on the campus or with the current academics can be clubbed in the indiscipline or the unfair means. It is not that they have caught me, the unfair means, these people who have rusticated me. That is my fourth ground. Fifth ground is that, my lord, I am losing my education by every day. Already the third semester has been started. Now the guides have been allocated. The research work has started. Now there cannot be a situation where I'm allowed to the classes but not to the campus because it is a comprehensive course where all the research methodologies are part of the entire campus itself. The tools that I use, the research that I conduct, the guide that I comply, the work with, they are part of the campus. So it cannot be a case where I'm allowed just for 3 to 4 hours of class and they say, you go back to your house now. No, my lord, the research is conducted in the residential program across, my lord, the span of the academic year, my lord, across the process through for 4 years or 5 years, whatever it is conducted. So, even the apex court has observed that, my lord, just because a criminal case is registered against a student, the right of education cannot be snatched away. And moreover, my lord, they have not referred. Now, Rule 11 is an afterthought that they are coming up with to justify their action. In their MPO notice, they just say your action has not left us with any course but to rusticate you from the university. They have not referred. In the similar case, the Khandelwal case that I have earlier referred, similar situation had occurred with the suspending authority had not mentioned on what provision that the students were rusticated. And the apex court has observed rightly, my lord, I have already submitted the judgment, my lord, that that cannot happen, and the students were permitted to go back to the college because the right, look, this time that I am losing day and again, this cannot be compensated by any means. That because, my lord, the academics are going on even today, my lord, as we speak. The original rustication notice has to go, my lord. Giving them time further of 1 month, my lord, it would just perpetuate the illegality. Moreover, my lord, where is the process? They do not have the power, from the day one, my lord, I'm requesting you for your lordship. They do not have any power out of the ambit of the campus for the actions that have occurred out of the ambit of the campus. So they cannot adjudicate. It is like a parallel proceeding that they are conducting. It is not, my lord, service law where I am in service of the government. Look, they are presuming this to be the service law and dealing it as if it was a service. My lord, I am a servant. But that is not the case. I am a student. There is a glaring difference in these two things.
Yes.
So, that may kindly be they do not have any power to conduct any further inquiry. That indiscipline does not pertain to the campus, the purported indiscipline, whatever. If I am involved, I'll fetch it before the court of law. Now they cannot say we are requesting for papers and we need 1 more month of time. So the rustication notice deserves to be set aside and quashed, my lord. I may be allowed with full powers to resume my research program and the classes. The clear judgment comes into my rescue as well, my lord. Writ petition which I have already submitted 1566/9 of 2023, where similarly they had it was an afterthought in that case as well of relying on a provision. WP number 1566 is already submitted. Also affects court judgment which is filed with my rejoinder Kita, Khandelwal and other. This is also a bench judgment, my lord, coming to rescue of student, my lord. Those relying on these two judgments.
Yes.
Yes, sir. Regarding WP number 1566, updated question in the judgment Washpal directed the authorities to conduct a fresh inquiry or may I read it?
Yes.
Please, however, equal to the respondent to proceed afresh in the matter if the respondent intends to during following by providing reason and following procedures guidelines prescribed in National Mental Commission for prevention and provision of acting in mental causes institution regulations and governing on the date and over the shaping of the Washpal directed to conduct a fresh inquiry. The proceedings are not concerns with the rules and regulations. Here also on the ground of technicalities, the investigation order may not go in because it is related to discipline of the students.
Yes. Anything further?
In reply to that, they had a procedure encapsulated. It was pertaining to ragging. So there is a proper procedure encapsulated, and the authority is vested with power to take the action. Here, there is no such legislation. There are no such rules that empower them to take the action. Moreover, para number 26/7 of the same judgment, it has been quashed and the liberty had been given to them. It is not the case where the suspension notice was not set aside. Para number 27 of the same judgment says that taking into consideration the aforesaid facts and circumstances in Sumit Mehta versus State of NT and full bench of apex court in judgment Ankita, Kailash, Khandelwal and others to State of Maharashtra, and also in view of the discussion conclusion arrived at as above, the writ petition is allowed as prayed for and the impugn notice is set aside. But because they had the authority had the vested power by virtue of National Medical Commission Prevention and Prohibition of Ragging Regulations 2021. That is the reason the liberty was given in that case. In this case, they do not derive any power from any legislation or rules. Para 27 is relevant, however, Para 28 is not related to the current case.
Yes.
One more judgment.
Yes. Pass on.
Here you got matter for the Central University. Vandalism has been put place. Preliminary discovery of 30 not provided any opportunity. At the stage, opportunity Yes. Last page, is back 26.
Yes.
Very good. One of the contention presented by the Constitutional Dictionary that second respondent was reserve suggestions and a rustication order should be passed against the petitioner if the second respondent passed such orders without applying the client independent within state contention. Any sensible person in the position of the second respondent would have done the same or similar acts on order, thus the vandalism and restore peace and tranquility to the premises campus of the university. Petitioners and the members of the university campus pursue their education and not to indulge in criminal activities. The incident that had occurred on 10/1/2020 was then a criminal act by criminals. The students who are admitted to pursue their education are not expected to indulge in violence of this when appellate authority had given sufficient opportunity to submit their explanation, the petitioner did not even produce any evidence in the circumstances. There is absolutely no merit in contending that still there is a violation of the principles of nature. The appellate authority, by eminent persons, the Bengal National University of Society, Kolkata, and they have taken into.
She's coming, ma'am.
Previous conduct of the petitioner, in fact, has already approached the previous involvement of the petitioner clearly shows that some of the petitions was indulgence in the acts of violence. Even earlier, and the imposition of punishment of justification of 2 years from petitioners 1 to 6 and 1 year in petitioners 6 to 9 in the fractional circumstances of the case is just as proper and does not call for any. Here also, initial stage, disciplinary authority not provided in opportunity. Appellate stage, every opportunity was provided, but did not interfere into the justification order. Only taking into consideration discipline and the tranquility in the university. Here also, even though they are involved in APSC examination, not in the academic examination, but it amounts to indiscipline. The conduct of the petitioner has to be seen in court. They are pursuing PhD course in court. Pursuing the PhD course, they are involved in pursuing. Yes. We are now ready to provide opportunity with the operating of inquiry.
Related to my question further. If vandalism is in question, it is been on the part of the campus is and they are suggesting indiscipline on that part. Moreover, here opportunity was provided, show cause was called for. In my case, not even a show cause. Even till date, even after initiation of this petition, they have not invited any explanation of whatsoever nature from me, my lord. Even when I submitted a representation asking them to conduct investigation or allow me to appear in the examinations also, they have turned a blind eye to the. It clearly establishes that there is malice on part of the respondents. 4.5 months cannot be a smaller time when we're talking about a candidate. They had, when they rusticated, it was an immediate act of rustication. Look, even if that is justified by any stretch, they still had 4.5 months to invite explanation from me or collect relevant material or take an informed decision or apply their mind. No mind has been applied in this case. It is a cryptic order of 4 lines saying you are rusticated until further notice. But what if charge sheet is not filed for the next 2 years? Should I be rusticated for 2 years just because charge sheet is not being filed over there? But those grounds cannot be entertained at this juncture, my lord. As I said, this is not service law that we are dealing with. And education, moreover, my lord, that indiscipline, my lord, again, as I pardon my lord for repeating, it nowhere comes under the definition of indiscipline, my lord. And
yes.
Rule 11 in that the university is relying is an afterthought. Even then, it is not applicable to my current case because I have not been alleged to be involved in any unfair means examination pertaining to my course. It is only alleged pertaining to TSHC.
Yes, friend. Reserved, yes.
Item number 12, Mohammed Azhar, GP for Education, GP for Services 1, GP for Forest.
11 to 14.
Yes.
11 and 12, just want to clarify. Pertaining to the permission in allowing of the examinations, there were 5 examinations. By the time the order could reach, 1 examination was already conducted. So they have allowed me to appear in the 4 examinations, and 1 examination had to be conducted. Whenever the lordships are passing final order, that observation may also be made to conduct my 1 examination that was missed. Because the order was not reached by the time the examination was conducted. So only out of 5 examinations, 4 examinations I was able to appear.
With regard to which matters?
With regard to 11 and 12. 11 to 14 are not 11 to 13. 14 are a batch, 11 and 12 with a limited relief of asking to appear before the examination, pending the repetition of the rustication, pending the final orders and the rustication is my prayer before them. I have given a presentation which they are not considered. So I had approached this honorable court, and this honorable court had allowed me to appear in the examinations. However, the direction to the respondents not to reveal my results. There were 5 examinations in total. There were semester examinations. 4 examinations I was able to appear.
You are not permitted to appear for 1.
I was not permitted to appear. It is not their fault. By the time the order reached, the examination had already concluded. So, Lord, may kindly observe pertaining to the 1 missed examination also, Lord, whenever your lordships are passing orders.
Is that applies to 11 and 12?
That applies to 11 and 12. 13 and 14 are comprehensive writ petitions
Yes.
challenging the rustication notice, rustication orders itself.
Yes.
All the 4 matters CAB.
Yes.
Item number 16, TSHC Kumar Patel Shankar Rao.
I am for the respondent, Your Honor. I requested time to file counter, Your Honor. Already counter prepared and sent it to Bangalore.
Yes.
Some time may be granted to file the same.
Who appears?
I am for the respondent number 1.
Yes, right. The petitioner is present at the request of the counsel for the response for the purpose of filing counter.
Page number 3, item number 70, Gajanan Chakravarti.
This is contempt. Dada.
What is the bundle you are giving me? This is in the badge. In the buzzer's badge. 1 second. 1 second. 1 second. Just wait for a second. Yes. Pass on the copy. Have you served a copy to the counsel for the petitioner? Yes. We'll close the content, giving liberty for you to challenge this. And petitioner approach the court.
Item number 18, G. Arun Kumar.
Order passed. Director, they responded to concern the application within 3 weeks.
Is not yet considered so far. Who appears for the respondent? Friend. Mr. Arun Kumar on behalf of the petitioner.
Item number 19, C.H. Venkatraman.
I take notice for the respondent.
Yes. Meantime. Yes.
Item number 20, A. Prabhakar Rao.
Yes.
They revised the structures. The representation was made to take action against
The order has been complied with. Yes, friend.
Item number 21, Siddharth Sharma, GP for Revenue.
Yes. 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 Thank you. Counsel for the petitioner is present. Counsel appearing on behalf of the respondent is also present. At the request of the counsel for the petitioner for the purpose of filing reply, this after 2 weeks, that is on 21st. Yes.
Item number 22, Argo Krishna Ravi.
Yes, Your Lordship. The recommendation is like, 1 million.
Yes. Yes, friend. Counsel for the petitioner is present. Learned counsel appearing on behalf of the respondent. This is memo number 7446 Public Services Roman 21 2000.
Number 6.
7th December, yes.
Item number 23, PV Krishnaiah, GP for school education.
Shall I send it to HIGHCOURT? I'll ask her. If she said then she.
Yes. Who appears?
Item number 23, PV Krishnaiah, GP for school education.
Okay.
Yes, right.
Item number 24 and 25, J. Venkatram Rama Narasimhan, GP for General Administration, Advocate General Ramesh Babu.
24 and 25 go together?
Yes, I'm representing 24.
Yes.
BC, the party, and it is to the BGC to file a count. It is coming for the counter of BGC. Then
You're not concerned with 25?
25 my friends here is a
Yes, right.
But issues are at the stage. The fact remains, item number 25 is filed by the students who has qualified the qualification for Hindi funded from Hindi Prachar Sabha. So this petition is filed saying that these petitioners has qualified the particular qualification which is required to be Hindi funded for this declared by the government. Thereafter, a subsequent GO 124 was also issued. Here, the qualification granted by Hindi Prachar Sabha was accepted for Hindi funded training secondary teachers. So far, GO 25 2017 is concerned, it was not included. That the matter was challenged before the railway bench. The division bench has set aside that and directed the government to consider the grievance of the petitioners by 11/11. But in the meanwhile, there is another notification has come in GO 25 2023 for the secondary teachers of the various languages. But in that also, the same 2017 contents are there, and it was just a replica of 2017 GO. Number was also not same 25. Then it was left open for the challenge before this honorable court, setting aside the GO, which is the replica of GO 25 of 2023 by this honorable court. But now, as an interim measure, the division bench is directing consider the application subject to result of the writ petitions or whatever the dispute will be created by government. So in between the notification has come, and these petitioners, those are the petitioners in the item number 25, they have qualified LP set, and for writing LP set, the qualification which is required for Hindi Pandit training is already being accepted. I have filed all these rank cards before this honorable court that they have qualified. My limited grievance at this stage, my lord, as the division bench has already granted permission to the other candidates to receive their application as an interim measure. But I pass on one.
Have you filed any IA to that effect?
But my grievance is that receive my application. So now your lordship can look at my interim prayer. But only
accept the application of the petitioner.
Yes, let us see the division bench judgment.
Yes, I'll pass. I'll pass. As an interim measure, I'll pass.
Yes. This is also for the same post.
Same, I'll pass on also division bench when it has been set aside the 2017 June 25. In the same APL period and Geo 25 2023, the replica of Geo 25 2017. That also I have been passed on.
Who appears for the respondent?
School education director.
The name is not printed. Randy. Counsel for the petitioner is present. No representation on behalf of GP. Yes, list on 9.
Item number 26, wait for the Tindival.
Filing the application was 27th October. Subsequently, also there are application filed before the division bench. Division bench is allowed to receive the evidence. What is my limited grievance unless and until the issue Geo 25 is decided? This repetition cannot be decided.
Yes, let him come. I brought your submissions on this.
The date of examination will be, they may not receive my.
I said only 9th. I've said 9th. Yes. In the meantime, inform him. Secure his presence on 9th. We'll pass orders. Yes.
Yeah, I mean, inform it, you can take them.
No, not tomorrow. 9th. Yes.
So it's not a
It will come. Yes. 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 Ready. And pass. Orders in the legal petition. Yes, 20th.
Item number 27, K. Prabhakar Rao, G. Praveen Kumar, Deputy Solicitor General of India, GP for Revenue.
Audio 12:35. 5 minutes, sir. Suresh is also here.
3 years, this matters.
Yes. Yes.
Well, the India, the government, central government introduced a scheme in 1972 with respect to do action to the sufferers. And later on in 1980, the central government modified the scheme and introduced the scheme under the Protocol Science Scheme 1980. There are such rules prescribed by the central government. But the aspect of the traditional hearing was concentrated in Hyderabad state is registered and they suffered the application of the 1980 scheme that this was processed and recommended by the special steering committee, allocated by the central government by examining and verifying the bona fides and substance and all these things. In turn, the state government also examined, verified the all of the scale norms and the recommended for which are which under the state government does a letter to the federal hospital letter.
Yes.
State government secretary to the central government. The reference is one to the application of the application of the subject approval and directed your attention to the reference sector. Reference second and third sector together with the original is reformed that the case of Sri Golapudi Gopal Rao. Golapudi Gopal is husband of has already been recommended by the Hyderabad Special Screening Committee and also recommended by the district after due inquiry and sent his report enclosing necessary documents and as such state government has also recommended the case of central freedom letter dated single 2003. This is the letter dated 13/1/2002 is recommended. This letter, it is categorical observed that there is a screening committee that the screening committee was put to the application filed by the husband of the petitioner that was recommended by the state government and the district government also recommended for sanction of the pension. And this is page number 29. Item number, the screening committee is agent of the number 273. Yes. The file number 112/944/97. This is the husband of this. This is not the dispute that the husband of the petitioner was participated in the whether he is eligible for pension or not. This is not the issue before lordship. He filed the application for extra pension in the year 1997. And the file was numbered as 117 of the 944/97. In 97 itself, he filed the application. After filing this application, after even a lapse of 2 decades, the central government not processed, not sanctioned the pension. And unfortunately, the husband of the petitioner died in 2005. During the lifetime of the husband of the petitioner, the central government wrote a letter to the state government asking for explanation to clarify one discrepancy. The discrepancy is rape is Gopal Rao and the Gopal Rao's other name is Krishna. Also, we can say death certificate page number 21. Yes. Gopal Rao, son of Krishna. The central government officers noted that is instead of Krishna, typed on some name of the as Krishna. And they wrote a letter to the state government to clarify whether Gopal Rao, son of Krishna, son of Krishna. And that was addressed by the this husband of petitioner the right of participant and page 26 is a clarification regarding to the name discrepancy. 26.
Yes.
May I read to address to the secretary.
Yes.
Understood the above, I said that instead your office on 24/6/2025 for the application. My father, Sri Golopat Gopala, it is land that there is a discrepancy in the father name, father name of application of Sri Gopal Rao, as in the application was written as Golapudi Gopala, son of Kistaya, whereas in subsequent representations it was mentioned as Kistaya. I submit that in village he is called as Kistaya and Kistaya, as it is a collateral name of the God Sri Krishna, and he is known with both names. It is a simple clerical mistake, and it should be condoned in the interest of tax justice. I also submit that it is unfortunate for my father as the agenda says number 273 and sanction dated 5/7/1997, application number 112 of 9 so, but in the computer reading of your office 112 of 181 of 1997, that's all. File number is mistakenly written in their office. This is also a technical mistake. Therefore, even though my father was referred by the state government, where letter number 1366 of 2004, after all the formalities, still pending for the above reasons. This is the explanation given by the to get through some because of the ventilator. The husband of this British applicant was at the time, subsequently 2012, that is the survey site in the page number. Number 21. That's it. That's it. He died before sanctioning the pension. Husband of the British. Now, the objection raised by the Standard Government to sanction the pension is that the subsequently revised rules framed in 2014. 2014, the revised rules state that Rule 1.5 says that.
Yes.
May I read one point?
Yes.
Sanction of pension after death of freedom fighter. No person shall be sanctioned in the name of the freedom fighter after his or her death, even if his or matter was under examination. This also entails that no lifetime areas or dependent pension shall be sanctioned to a spouse or daughter after death of the freedom fighter. So, and there is no pension sanctioned during his lifetime, according to the 1.5 law. The widow of the pension was not entitled, so that is rejected. Then the approach, by the petition, this Honorable Court directed the respondent to consider the application filed by this petitioner in the earlier round of petition, that is in the order is in petition number. So that consider the interpretations of the petition. And after considering this interpretation, the impute order was page number 70.
17.
17.
Yes.
This is impute order. Actually, the start of this impute order speaks that to understand that the state government applicant, the state government, channel 4 into 5 of the relevant, page number 18. Channel 4.
Yes.
It is pertinent to mention here that White Ministry letter so dated 4/5/2005. The claim of late G. Gopal, husband of the minister, was referred back to the state government office for application of discrepancies between the claim made in application and the report published to the state. However, there was no response from the state government. This is why it is a record question scheme, and the absence of the submission of the document from the state government. In case of Gopal, would not be considered in his lifetime. Moreover, after lapse of 2 years, they were putting this petition on the whereof. As pursued this matter, in court by filing petition number 42241 of 2017 in the High Court of the state of Telangana. At paragraph 6, it is further stated that federal pension was never sanctioned in the name of late Sri G. Gopal Rao during his lifetime, and paragraph 1.5 of the revised policy guidelines dated 6/8/2014 states that no person shall be sanctioned in the name of freedom fighter after his death is even is our matter was under examination. This also entering is that no lifeline areas of different science are scored. The claim of Srimati was examined in like of the court order dated 6/20, answering the regulation dated 25/9/2017, and all the records available in the ministry and in consultation with the produce of the Somni Saman Yojana scheme 1980. Since the person was never sanctioned to her husband during his lifetime, he has not been found to be eligible for family pension as per para 1.3 of the revised policy guidelines dated 6/8/2014, which is stated above. The Golapuri Velamma does not meet the eligibility criteria of SSY 1980. It is therefore regretted that she is not eligible for claim of the federal family pension. Hence, claim is rejected. In the similar facts of this
they went to Bala Bhaskar, sir. Now sitting in our chamber.
This group in Kerala. This is one Chittappa project started of Kerala, and the case was considered with the court. And during the lifetime of the husband, and our application was considered the Honorable High Court of Kerala directed to consider the application, and this 2014 guidelines were is not retrospective. Their husband filed application much prior to revised policy, revised rules, 2014 rules. As such, the Kerala High Court directed, and the central government filed a review that was dismissed, and the matter to Honorable Supreme Court. The Honorable Supreme Court confirmed the apparent that is filed judgment by the Kerala High Court. Also, the guy said that judgment based before.
Page 43.
1.5.
That's at 43.
Let the page number this Chalama is 43.
Yes.
If I know part of the judgment of the Kerala High Court, this part is number 14. Paragraph number 9 is the page 44.
Yes.
This Honorable High Court of Kerala, this observed the 1.5 which clause, revised clause, which I read before.
Yes.
The applicant relies upon clause number 1.5 of the new guidelines for disbursement of the pension of the Union of India, which discuss 1.5 sanction of the pension of death of freedom fighter. No person shall be sanctioned in the name of the freedom fighter after her death, even if his or her matter was under examination. This also entails that no lifetime agents are dependent for shall be sanctioned those matter after death of the person. So this is the on the other hand. So this is the submission made by this respondent in paragraph 10. But 11 is that as it may, it is only unnecessary for us to interpret the new clauses of the new guidelines. In this matter, we know the fact that new guidelines have no applicability to the case on hand and as observed sutta. Therefore, the first condition of the applicant fails. So far as the second condition, it is doubt that application has to be rotated through the state government to the union. However, such condition was not at all raised at any point of time here before any other authorities, including this court. Be that from paragraph 4 of the judgment, so amply clear that applicants are sent to the state government. In this case, also they understood state not to the applicant about the results or clarification of discrimination. Paragraph 14 last 3 lines. This is paragraph. In view of the above mentioned, it is not open to respondent has submitted a copy of the application to state government, and state government has given valuable report on verification of the facts in favor of the respondent. Having regard to the proposal of the facts, the land single judge is justified in allowing the petition filed by the wife of the freedom fighter and dismissing the renewed petition filed by the Union of India. Accordingly, no interference is found with the writ of appeal and some fact dismissal. So against this the take the approach of the Supreme Court, page number, last page. Supreme Court of India, last page approach. Supreme Court of India. Item number 20.
Yes.
But the dated 24/7/17, this petition was called for an hearing. The last delayed unknown. Special petition dismissed. Pension shall be released within 1 month. So the end of this. Simple 1 second is going to be self dispose of the matter. Confirm apparently is Kerala.
Page number?
Page number. And actually,
Last page here is the wakalat. Yes. Yes.
Counter.
Civil rights of the case, I told you there was a different. In the RP6, there will be matters.
Page 46 of the book.
Okay. Expedition.
Yes.
Under the judgment reported the Secretary Government of India and others, the court has said the object of the scheme is to provide pension to freedom fighters and their families. When the scheme is introduced to the benefit of the freedom fighters, the entitlement cannot be threatened by mere technicalities. Provision of the scheme shall always be interpreted and given effect only in favor of the freedom fighters. If claims are negated on mere technicalities, we will be failing in our duty to respect those who had undergone the ordeal and the misery and necessary in getting the freedom. Considering all these facts and the orders of the correspondent rejected that of the petitioner is legal and is liable to be succeed, and academically it is hereby succeed, correspondent is directed to the petitioner under SSP from the date of application within the period of 12 weeks from the date of receipt of the order. So in this case also, the technicality raised by this respondent is the freedom fighter name is government. The applicant name is the government. But his son, his father name is loaded as Kistaya in one place. Kistaya is Kistaya. That is the discrepancy raised by the respondent, and they consider that for clarification, they refer the matter to the state government. State not responded as such. His application was kept pending and not granted. After death of the husband, the wife of the this applicant approaching this central government for functioning of this application. Now they are saying that there is a delay, and another fact they are saying that after death of the husband, as per 1.5, this rule, she is not entitled. But no order has been passed against the order of application filed by this husband. Only due to technical mistake kept pending for last 20 years. Now they are saying that he is no more, and as such you are not entitled. Whereas the Honorable Supreme Court upheld the order passed by the Kerala High Court that 1.5, this rule rule amendment is not retrospective and does not applicable to this, the subsequent rule to this earlier case. As such, this particular case, the applicant filed in the 1997 itself, but whereas the amendment took place in 2014 in 1.5 rule, that is during pendency of the to the lifetime of the husband, only subject condition to sanction the pension. But the lifetime of the husband, no order has been passed. And 1.5 amendment is in 2014. And as per the Supreme Court to this observation, apparently Supreme Court, High Court order of the Kerala in September case, that is squarely covered by this factor, madam. Such this applicant is entitled for seeking pension. And the rejection of pension on the ground that 1.5 of the covering the considering 1.5 is not proper and not the guidance of the US Supreme Court guidance. And there are some other judgments.
Yes, we'll hear the Standing Council be there.
One more observation which the Honorable of Chief Justice is partner to your Lordship Satish Chandra Sharma while studying the other this matter, attends to federal matter. The fact of filing of earlier petition not in this. However, court is dealing with the case of extraordinary person who was a freedom fighter. And on account of whose efforts today we are breathing in a free country. The widows of such freedom fighters cannot be permitted to beg before the authorities. Now, this widow of the freedom fighter at the age of now 85 is coming before this honorable court with great difficulty, seeking for pension on account of suffering of her husband, late husband. It is not disputed that her husband participated in the freedom struggle or not, suffered or not. That is not disputed. Technical ground is his name was noted as Kistaya, and he is no more how you are acting. That is two aspects of raised. I find some sentences covered matters I read below.
Yes.
Page number 11, page number 1 is the Supreme Court. That's why I passed the card. Page number 1 is the Supreme Court confirmed the apparently judgment was by the Kerala High Court. Also. So,
yes.
And page number another judgment. Page number 8 last. Page number 8
yes.
The standard of proof required in such cases is not such a standard which is required in a criminal case or in a case adjudicated upon rival contentions or evidence of the parties. The object of the scheme is to honor and to mitigate the sufferings of those who have given their all for the country. Liberal and not technical approach is required to be followed when determining the merits of the case of the person seeking pension under the scheme. We have noticed with the disgust that respondent authorities have adopted a hypothetical approach when dealing with the case of the freedom fighter and ignored the basic objectives of the scheme intended to give the benefit to the sufferers in the freedom movement. The contradictions and the discrepancies, as noticed in the above, cannot be held to be material which could be made basis depriving the appellant of his right to get pension. And in there are 10. Accordingly, appellant is allowed setting aside the order of the High Court and also aside in appeal in the order of the respondent. So the appellant is entitled to the grant of the pension by the state of Punjab and the conservation. And then the other case, there are things of them is the establishment of Punjab High Court and in number 2 last.
Yes.
Late husband of the prisoner was enrolled as Service. That number 3. Notice being issued, separate notice of the right by the Union of India and by the state of Haryana, Husband 1 and 2 in their counter advocate submitted that in order to eligible for pension of its king, application is a work and that the application of the husband of the petitioner was not everything. That is why the pension was not granted. It was further submitted that pension had been granted to only 37 out of 40 facility for available as well. It was further submitted that the requirements of the eligibility criteria of the scheme is detailed in clause 2 and 3 of the scheme. The claim has further been restricted by placing reliance upon para 1.5 and 5 of the revised policy dated 16/2014. This matter also same on the same guidelines they have rejected and but this one of the central government text. In their submitted that time of release was considered and it was found that this was not eligible to para number 1.5 of the guidelines. Till further it was submitted that since the husband of the petitioner being granted pension to the scheme, the petitioner was not eligible for this scheme. Still further, it may notice that parents 1.5 of the guidance came up for implementation to the Honorable High Court, Kerala, in the RP number 1, Union of India. It was handled under. The rest of one guidelines would be full. The way the process is handled. There are 10 levels. Central government council will rely on para 1.3 guidelines in order to ensure that that's of the federal sanctioning the dependent pension on the legalized service para 1.5 of the election. Same reproduced as such. Federal college para number 17 that the result input order taking so after the direction is issued to respond to forward the application of this law, which is the report for pension as dependent of the disease period of scheme to the respond was to the period of 4 weeks from the date of receipt of certificate. As the fact that petitioner is already more than 8 years of age, respond 1 and 2 are directed to consider and decide the application. So this will be within a period of 4 weeks thereafter, and the grant of person that their condition is what the application is not available to the assets. Now these were directed to consider the application and to answer the question.
Yes.
The late husband of the petitioner was ever hard clear to pass in the order, and hence apparently the order of denial either it is the order dated so date or that of so date, but without providing any opportunity of hearing the late husband of the petitioner or to the petitioner herself, hence it violates the truth, and hence it cannot be sustained in the eyes of the law as a matter of people dead person. And 82 laws. The court just publishes the writ of pension allows the invitation for the name of the benefit and process simple laws dated so it's election. The part of rupees 3,50,000 who is paid to the widow for the harassment for which her late husband verified and she had suffered at the hands of the state agency and 82 laws. The rate of pension issued to the respondents before me not paying better pension all the as admissible to the definition without any other reason. The prisoner, which is 91 years old, no, and pay the entire interest of the which was otherwise paid to the husband. Prisoner widow. In this case also, during the lifetime of the husband, no order has been passed. After death of the husband, after lapse of 23 years, they passed an order that her husband gave the dismissal, and state government was not responded to their letter. And saying that it is either nothing but must enter 10%. You know the facts with us. Only question before also in this case is whether 1.5 circular guidance to the letters should Honorable Supreme Court upheld the Kerala High Court in Chittagong as such. This case also 1.5 does not apply. As such, is fairly covered by the benefit and the minister is entitled. Now the minister is 85 years age. He is struggling for survival. He is bedridden, and during lifetime of the minister, if the state respondents fails to sanction the pension and the legal acts are not attended as per scheme. Now the widow is covered by this 1.5 crore. She is entitled for pension.
Yes.
And if she is no more, and this scheme does not attribute the legal income.
Yes.
So being failure of the husband, widow of the husband, who is the person suffered in this struggle, only the entity. As such, by submission, rapid submission, not should be concerns at the earlier without giving any further adjournment because she is already bedridden.
Yes.
At least she may see the fruits of this scheme in the last hours.
Yes. What do you say insofar as the judgment of the Kerala High Court upheld by the Supreme Court?
Judgment which the level of the definition of this area that was referred by the state court. Here, this case of the petition of suspect was not referred by the state court. We have clearly mentioned the rejection order. Your Lordship, 93 page 80. And if you guys have submitted your Lordship. Paragraph 4, your Lordship, is kindly see.
Page
18 of the petition.
One eight.
Of the petition, last 4 lines.
Yes.
The SSS way the report was scheme and in absence of submission to documents from the state government, case of the state is over would not be considered in his lifetime, nor after a lapse of 12 years, whether the government has pursued this matter in court by filing the repetition in pursuance of High Court of Telangana. In persons of the directions in this repetition, your Lordship, her case was considered and rejected. Now, your Lordship, you can see of counsel, your Lordship, why it has been rejected at page 3 of the counsel. Decision was undertaken by the state government upon a large number of fake applications in Congress. This included auction cases as well as fresh applications. Respective document, your Lordship, which has to be received, dated the repetition, your Lordship, will contain page 28. Page 28 of the repetition, your Lordship.
Yes.
It's dated 31/2004. This re-verification was directed to be considered, your Lordship, in the year 2007, which we have stated in page 3 of our counter. This re-verification was not conducted by the state government, your Lordship, and this report was not received by the ministry. And clause 1.5, don't think that's read, your Lordship, for page 20, your Lordship, for our verification.
Yes.
Page 20 of the counter, your Lordship, clause 1.5. sanction of pension after the death of freedom fighter. No pension shall be sanctioned in the name of freedom fighter after his or her death, even if her matter was under examination. This also entails that no lifetime arrears for dependent pension shall be sanctioned to his or her spouse daughter after the death of the freedom fighter. In this case, your worship, the husband of the petitioner was never granted pension, and he was not, his application is not under even examination, due to the reason that the re-verification report was not received from the state. They have not conducted the re-verification, your lordship, that report has not been submitted to the ministry. That is the reason, your lordship, based on this clause 1.5, the claim of the petitioner was rejected, your lordship. And earlier, your lordship, she filed one petition in the year 2017, your lordship, which I have written paragraph 4 of the rejection. In pursuance of the directions of the Honorable Court, your lordship, her case was considered and rejected only on the cause that the re-verification report was not received, and also on the clause 1.5. The judgments which the learned counsel is referring, your lordship, of page 45, your lordship, of the petition. I think your lordship dependency.
Yes.
It's been in communication issues by the government of India, the government of India, to the additional secretary to the government of Kerala. It is amply clear that the papers are sent to the state government, and the state government has recommended the case of the respondent petition. However, the respondent has submitted the application not only to the government of India, to the state government, but also directly to the government of India. All these cases which council is referring to, in all these cases, state government has submitted the report and duly recommended the case of the petitioner's, your lordship, for sanction of the pension. In the present case, your lordship, there is no recommendation from the state government, nor the re-verification report submitted by the state government. And last, your lordship, we kindly turn to page 49, your lordship, judgment which the council is referring.
Page 49 of the writ papers.
Writ papers, your lordship, judgment at para 21. Further, the state government officers have implemented case of the petitioner and seen from the proceedings of the district collector Madurai, dated 26/7/2006. The district review committee has also recommended the case of the petitioner. As stated, the case of the petitioner was rejected only on the ground that there was no suit filed by the petitioner in the district court regarding the undergone period of the petitioner's husband, and NARC non-availability of record certificate was not in the prescribed law. In all these cases, your lordship, state government has recommended. The only difference is that, your lordship, in the present case, state government has not recommended. In one of the judgment which the learned counsel is referring, along with the memo which they have filed, your lordship, in page 17. Page 17 of the citation which they have filed along with.
Yes.
Paragraph 4, your lordship, page 17. Thereafter, right for period finance pension, family pension to the state government, which was duly considered and sanctioned by the state government authorities by the order dated so. In the same way, the petitioner has also applied to the respondent, the central government, for getting the central government freedom pension in respect of all the available documents and information. The report based, your lordship, all the documents has to be submitted and the re-verification reports has to be received from the state government, which is a mandatory procedure, your lordship. And then only the case will be considered. In this case, your lordship, petitioner husband was never sanctioned pension due to the non-submission of the report, and also, your lordship, the petition is not entitled on the ground of clause 1.5. Is all submission.
You are referring to clause 1.5, and further, what was the other submission?
Further submission, your lordship, is claim of the petitioner husband was never under examination or considered by the ministry, your lordship. When he sanctioned the pension, your lordship, the wife of the deceased wife is entitled for the pension. That is the procedure, your lordship. In this clause, it is clearly mentioned 1.5 at page 20, your lordship. This case was not even under consideration. If he has submitted all the documents and his case is under consideration, that may be a different issue. But his case was not even under consideration by the ministry. Non-submission of the documents, re-verification report from the state government, and also he was never sanctioned the pension. Petition has only 1.5 the figure of all the petitions that we followed based on the.
Again, I looked at the vision that is no recommendation by the state government. It's the
Page 28.
Page 28.
Yes.
That this is a letter understood that the state government secretary to the central government undersecretary to the government minister of home affairs, who is the advocate authority pursuing this spread of information matters. Subject matter. So this is someone who says the candidate advocate special screening committee. The subject matter. And of course, one is the letter understood by the this first was this central government dated 26/3/2003. The application of reference 2 is the application of the husband of the petitioner. No, so and so. And the reference 3 is where not the other applicant only what is a sanction in favor of the third applicant. But except the was obligate places. I am directed to invite your attention to the reference first cited. First cited reference is the now by landlord stated that some clarifications sought from the state government. No response given by this state, that is the landlord's condition. But I am directed to invite your attention to the reference first cited and to conclude and to enclose the reference and the conclude reference and second and third cited together with its enclosures in original. It is informed that the case of Sri Kollamudi Gopala and Sri Kodeswara of Common District has already been recommended by the Hyderabad Special Screening Committee and also recommended by the district collector come out after due inquiry. And the central is report enclosing necessary documents, and as such, this state government has also recommended the case for grant of pension by letter dated 2003. This letter shows that already dated 2003, state government recommended for sanction of the pension in favor.
Yes.
And then my land stated some other cases that is performed these things but to do my because I happened to, my father also happened to send for prison in more than 2 years in Gulbarga thing. As such, I know some facts of it. But going to Sharaf, Gulbarga, there's an earthquake kind of state. He was headed by this screening committee. Because the central government constituted a special screening committee as referred to subject matter. Special screening committee, members of this special screening committee, the participants in the state of struggle. Hyderabad state venture struggle in India will use the struggle even after continued even after 1915. But at that time, Hyderabad state was not liberated. It was the independent state. As such, so the people of the state continued their struggles for better of the Indian Union. But ultimately, in 1949, 17th September only, this state was liberated. As such, till 1949, September 17, the struggle has to continue better. But the Govindra Sharaf was headed by the Special Screening Committee, constituted by the central government to verify, to scrutinize the sufferings of the applicants. And after Govindra Sharaf, the veterans of this freedom fighter revising the committee, and that committee scrutinized this application filed by the Gopal. And they were duly recommended to central government.
Yes.
Yes. Some government consider the state government was recommended. That is the fact.
Yes.
Our counter-equation of the decision which was taken by the state government, subsequently it was a state decision to reconsider and to submit the report your worship. In whose cases they were recommended and whose applications were sanctioned. In those cases also, as the fake documents have been submitted, the re-verification was directed to be state government. So should we continue to the date that is 2004, in 2007, the state government has taken the decision, you know, to conduct the re-verification. So they conduct the re-verification. That report was not received, that is the.
Yes. Rent.
Till now, there's no medical, there's no letter, that the letter, the widow of this petitioner was eligible for pension or not. This is not the case of the central government that he is having this some fake documents, he is not eligible, he is not somewhere. It is not the case. Now, this to get the pension to this petitioner, now they are raising that some of fake applicants filed applications for seeking pension. As such, we are referring the matter, all the matter for fresh reports or fresh verification. Who prevented that? But the petitioner shall not be suffered for the mere your completion of the reference all these things.
Yes, rent.
Item number 28, Ali Ahmed Basit, K. Ratangapani Reddy.
Requesting this matter be taken up on any other day. Yes,
Yes, I'll say tomorrow. Yes. After 20th? What do you say? The petitioner is present, the counsel for the respondent is present.
Praveen Kumar, Deputy Solicitor General of India, GP for Home.
It takes some time. If it is, it will take some time. I'll post it at 2:30. Yes, soon after passwords and lunch motion. Yes.
Item number 30, B. Rajeshwar Reddy, A. Venkatramana.
Yes. Yes. Any orders passed in pursuance to the orders of this court dated 8/8/2023? Have you challenged that? Amendment is filed? Yes.
I am please to amend the rest.
Yes. And serve the amendment. Mother, come on.
Page number 4, item number 35, E. Subhashan Rao, G. Praveen Kumar, Solicitor General of India.
Speaking.
Filing of this request, who is permitting the petitioner to travel across.
Yes.
And we have scrupulously complied, always reporting back before any time expires.
Any fresh IE is filed?
He is fine.
Yes.
And in fact, the schedule was to travel before vacation because they could not reach. Those tickets have become.
Is what do you say? Page?
Page 13, the principal previous.
Page 13 of the red papers?
Earlier order.
Earlier order you got. Dated 13/6/2022. Page 13.
You know, no objection reported. That was the order passed.
Neighbor restrictions. Last for the same conditions.
Is what do you say? Order at page 14?
No, this is the order, the same order which they wanted to pass.
Yes.
But the prayer is for, this was only for 3 months. The request is for 6 months for the simple reason. But last time they gave the chaotic citizens have 3 months. And after the expiry, when we are finding IA, either it is not reaching for various practical difficulties, the tickets are becoming a waste. So the prayer is for 6 months. Especially in view of the condition that there are no proceedings pending against the petitioner whatsoever. And there is no counter in the restricts until now.
Yes, right.
Yes, all conditions will come.
Same conditions are at page 14.
Yes.
The council for the petition.
Yes.
Since he was not holding the student, I thought it central government needs to be. But since your lordship has, then his lordship have directed in this way to matter, get the file before the chief, so that the next thing can go. And that's how it has come out. That they are not getting 2003 is the latest, expired in 2018. February 2022 onward, they are not paying. In fact, your lordship in the order. And I just take two facts, then I leave it to the lordship. It is covered by your lordship's order. I just take two facts, then I leave it to the whether to what extent they are justified, nothing like information. But petitioner before your lordship is most of the property.
I understand. I know the facts. Yes.
Yes, this is the order document. Identical facts, but 2018 is expired, 15 years late. It expired in 2018. February 2022 onward, they are not paying a single fine. But I find photographs. Now we are in 23. The outlet is lying inauguration since 2009 and 10.
Yes.
It is not straightaway come to the operative force. Last page of the order.
Yes, I remember that order.
Yes, this is the order copy. My notes were referring to on the previous date when the matter has come up. Let para 16 may invite.
Yes.
That taking into consideration the above facts and circumstances, in here the view taken by the apex closure in judgment reported in 1999 for STC, page 450, HPCF, so and so. The response are directed to vacate the premises, that is OFAS Act, to an extent of so and so, within the 3 months from the date of receipt of the copy of the order. But facts are 2003 period. Petitioner, in this case also, 2003 is the lease agreement. 15 years entered into vessels IPP. In the present facts on hand also, they are identical. To what extent they are justified? You are not see the photographs that I am finding.
Yes. It was orders, only accommodating them.
Yes.
Next week.
Oh, not next week. I'll say 10th. Yes. 10th. Yes, for orders on 10th, right? Yes. I'm only accommodating them.
Yes.
Order will be passed. Yes. Yes, heard the counsel for the petitioner. The learned counsel for the petitioner brings record order dated 11th September 20.
Ullah Khan, Mohammed Moinuddin, G. Praveen Kumar, Deputy Solicitor General of India.
All three go together?
Which I made a submission in the morning.
Sleeping.
Again, this matters councils have been filed. What you can pick the date of the 17th or 18th.
The third time this similar submission is being dropped. I came from the last occasion also, they have taken time of finding a contract. Today they themselves have taken this date. I came all the way from Bangalore. Now they are making this submission. These are the national guarantees because petitioners are inside the jail and their valuable rights are getting infringed also.
Earlier addition from Chennai has.
There has been a recent change with this council.
It's shorter date got, not 17, 18 got. That's a very simple matter. Just only one short legal point is involved in all the matter.
Item number 44, Naresh Reddy Chinnola, V. Ramchandar Gaud, PG Ravindra Reddy, GP for Civil Supplies.
Yes, right. Still at the request of the council for the petitioner. This one, you want it on 9? This on 9.
Item number 45, Naresh Reddy Chinnola, V. Ramchandar Gaud.
All the three matters.
Item number 47, Vedana Srinivas, T. Suhasini, C. Damodar Reddy.
Yes, friend. It is represented by the council for the petitioner and the council by 24th council for the cause of action in the present petition does not survive for the adjudication anymore. Pending the said submission and record, the petition is dismissed as infectious. The interim orders granted in 17/4/2014 stand vacated. Yes.
Item number 48, NV Subbaraju, IV Ramesh, DV Srinivas Rao.
Representation will be not.
Item number 49, C. Damodar Reddy, GP for certification, NV Rajkumar Gabriel.
On the filing of the petition of the respondents are last petition taken correction.
Last, there now, they are there on online. Right, I'll post it tomorrow. The petition is present, no representation.
Page number 5, item number 50, Prabhakar Chipura, GP for General Administration, GP for Medical.
And I didn't sign the clear to register the numbers. They filed the review petitions, but let us see the council the review petition.
On behalf of the, no papers, sir, sir. I'll post it next week. Yes. I'll say 16.
Let's inform that we are served the clerk of the respondent. He said, I got the instruction from the clerk.
Yes, anyway, I'll post it on 16.
16.
Convenient, 16 for the senior council. Yes. List on 16.
Yes. Item number 51, D. Padmavati, GP for revenue, GP for assignment, D. Narsimha Gaud, and Venkateshwar Rao.
Yes.
I beg to refer to this. Come for the argument of the government leader. Concerning assignment of 5 acres of land.
Yes. Is he here? No. Pass over. Yes.
All the journal matters are in Chief Justice Court. They are under adjudication. After that order has come to court, but same kind of case have been heard.
Clarification I would like to make. One clarification I would like to make. Those petitions which are pending before the division bench are not concerning to the similarly placed petitioner. The petitioner was allotted. They were not at all allotted, but they were claiming their rights under some bogus patterns. It's totally distinct.
Yes. Pass over. Yes. 52.
Some of them claim assignment, some of them claim duration, but some of them
some of the matters, the.
Let this matter also go before the first court.
But,
Yes.
That is the representation. That this matter also can go before the first court.
well, it's totally distinct. But not a more semblance of resemblance is there, not concerning that batch pending over there. Nowhere more they have stated that.
Let us see. Yes, the next.
Item number 52, Chandrasen Law Office, G. Praveen Kumar.
Alex Munot, you also do a
Yes. Let us hear the learned senior counsel. Yes.
Society is not a party, society is a party minutes. Probably instructions will be given to me to appear, but society is not a party.
Alex Munot, you also do one thing. If they are so well, let them file an affidavit that these are corrected similarly. Likewise, the same matters are pending with the bench. But they cannot represent like this. My class of action is distinct. And the original
Yes, let us see. Yes.
Item number 52, Chandrasen Law Office, G. Praveen Kumar, Deputy Solicitor General of India, K.R. Koteshwar Rao.
So I'm writing.
Yes. After lunch. Yes.
That's more better. Item 8. 20, 8 అన్నది మరి క్లోజ్డ్ ఇది. Your number is second. So I cannot say. Item 6 in this one.
Creditors.
Silence.
My colleague requested password. You do on Monday, not that.
Yes, right.
Monday.
Monday, I think, is on holiday. 14th. 13th, I was told, is a holiday. Yes. List on 14th. It's list on 14th. Yes.
Lunch session, page number 1, item number 1, the speed thing.
इसमें नोटिस में चल रहा है
Yes. Yes.
You are at page number 11, the timetable for shows by the university. From page onward, the examination was. Actually, we have challenged with a lot. Number 9. The allegation was made on my client, Your Honor, that he has engaged in consumption of selling or any of political substances, but there are no proof, they have not given the opportunity to the petitioner, Your Honor, to attend the meeting or whatever. Directly, they have given the dismissal order. Meanwhile, let him write the examination process.
You have not suspended. You have not sought, you have not, your prayer doesn't seek for suspension of this order. 9, where you have said.
At last, where I request either the student or the parent or consider the report that is the order will be taken up by the competent authority.
Where did you say that? Page?
Page number 91.
No, your prayer in the writ petition, you have not sought.
Page number 8.
You have not suspension, you have not sought for suspension of this proceedings. 26th October 2023. You have not sought a prayer seeking suspension of this proceedings.
Actually, Your Honor, it is page number 7. Last paragraph.
Yes.
Declare the action of the respondents in issuing the interim dismissal order.
That is the main prayer.
And the interim prayer is page number 80.
Yes.
Further prayer is on the report which seeks to direct the respondent hearing to permit the petitioner hearing to attend the first semester of 4th year of examination.
Yes, who appears for the respondent? Anybody appearing online?
What is it?
Do you have the copy of the memo? Where you have,
Yes, sure.
yes, pass on the copy. Yes. And what the consequence of the petitioner? In pursuance to the orders of the school dated 2nd November 2023, the petitioner
16.
Yes. 16.
16.
16.
Item number 2, C. Vikram Chandra, Tom Srinivas.
Court of Server. Chivatti, original bundle, duplicate bundle. Here has to be changed. Taking suspension is in. Yes.
Please to subject for the petition in this matter. We show purpose in the right petition for the retail outlet industry which has not been allocated to this petition when he has satisfied all the eligibility criteria. Our last location which matter was argued at when the launches for so places to pass and stay order in IE number 1 of 23 members. It was there the operation stay order is effective for a period of 4 weeks.
Yes.
No, my lords, I have.
Any counter that's been filed? Yes. You have filed a fresh IA?
Yes, this is ID.
Yes. Yes, right. Yes. The respondents find the council this after 3 weeks, this after 3 weeks. It is on 20 November for the council. Yes. Yes. It's not been dispatched? Yes, shouldn't have. Look into that. Yes.
Sorry.
23. Yes, call the next case. Yes.
Pasavas matters, page number 1, item number 1, says Law Office, G. Praveen Kumar, Deputy Solicitor General of India.
Wednesday.
Yes.
May.
Yes.
Respondent sought for crossover contending that there was similar writ petition filed, it was disposed of by this honorable court. For that, they may have to submit the writ petition which was filed questioning the similar order. If it is not, then I may be permitted to submit otherwise.
This order is not against the petitioner, it is in favor of the petitioner.
True, ma'am. In case if they are referring to WP number 38065 of 2022, then it is protecting me, my lord.
Yes, absolutely. Yes.
Case for
Any final orders passed?
That was similar to the Honorable Court, Justice Lakhnagar has ordered the petitioner to convert the PP as a CAP and section Article 2 of 7 Constitution.
It's an order passed by first step of it. Proceedings are there.
Was it, was it passed in the very same writ petition? In the same writ petition? Final order?
Convert the second petition as a revision.
Was it a final order?
So final order.
Final order.
Final order directed to convert here.
Yes, we'll pass the same interim order and we'll pass the same direction, right?
But I take notice for R1.
Yes. 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 Yes.
Also, the market is
yes.
Even if you are going to practice one space,
Yes. It's right. The learned council, learned senior council.
It's subject to leave, Millard, when we compared with the, when we checked the case status on the line, Millard, still this WP is pending, Millard, not being converted.
That was a direction to the learned council to take steps for conversion. Yes. Yes. I said 6th December.
Ublai.
Yes.
Ublai.
Yes.
Item number 3 and 40 goes together, ma'am. P. Lakshma Reddy, G. Praveen Kumar, Deputy Solicitor General of India.
Yes.
3 is the fresh matter. 40 is the old one. This is fresh. This is 40.
Yes.
By challenging the common
reply.
Saying that Hyderabad somebody and authority to go away because finding is that there is nothing, no material against me. Even the sample which has been collected on the way to waste, also that they, according to them, that they've sent it to the analysis report has not come so far. That is what they have stated in the even today, according to my instructions, are still to the connection. Test has not been identifying whether any prohibited material is there or not in my product. I'm manufacturing the product which is normally nominally called as 3C. I've got every license to manufacture. Out of 118 kgs which was manufactured, 100 was being transported, it has been intercepted and action has been initiated.
immediately at the same day, in my premises, when the manufacturing unit is here in Hyderabad. And I've inspected the seized the remaining 80 kgs and then seized the material has been placed before the court. But my request in this requisition is to send the sample for the quantitative test because it will be clear from them whether there is any prohibited.
What is the difficulty insofar as interim prayer in the present writ petition is concerned?
The interim prayer is this. Basing on the pregnancy kit that the officers have, they've intercepted the drug turned into yellow color. They came to a conclusion that psychotropic substance existed. Subsequent to that, and summons was issued by the DRA. Who is not the investigating authority. DRA is the investigating authority. They alleged that only with mere suspicion they issued a notice. Over at that point of time, they have not asked for anything else. They said that mere suspicion that a psychotropic substance was existing, we have given so and so. In mere suspicion, they cannot summon me. Hence, they stop a direction in the summons not to take any course steps to further vacate petition. Now that they ask is to conduct it before a different set of considerations. Next, the FSL report is not out yet. Today, we are waiting for the FSL report whether this drug that we are referring to, this is a very complicated chemical analysis that is taken into consideration. We are given it for FSL report. The FSL report in the last date of hearing before the trial court has stated it, due to some technical problem that they were having, they couldn't give the report on time. Requested for some more time and the court has accepted it. Then the FSL report is not out yet. Asking for a subsequent report will prejudice my investigating officer. Because as of today, the FSL report is not out yet. But their content is twofold matters. First, that they say is the initial drug test that they have conducted doesn't give a proper clarification for the simple reason that only turning the color into yellow will not inform the existence of a psychotropic drug. Well, it's throughout the investigating officers, whoever they investigated, they do it with a drug kit that is available to them. Basing on that report only, they arrest people. Well, it's here it is not mere anticipation also much. Well, let's kindly take item 40. Even in the remand report, where the other 5 accused were being taken into consideration, there is reference to this petitioner's match. Let's kindly take item 40, petition 24370 of 2023.
Yes.
That's page 43 is the remand application that starts with.
Yes.
Let's kindly see page 50, para 11. Very good.
Yes.
The statement of the accused number 5 was recorded and so and so, accused number 1 to 4 recorded and so and so. Under section 67 of MBPS Act, where it has come to the knowledge that so and so, Sandeep Kumar had received purchase order from MBC Pharma, Netherlands of 100 kgs of so and so substance, who in turn placed an order of 200 kgs of the said product from AB Enterprises, situated at so and so, the Gatpover. Through Sandeep Kumar's firm Vice Dhanlakshmi Life Sciences Limited, Faridabad. Further, AB Enterprises placed an order of 200 kgs of the said product from Medchem Labs, who is the petitioners here in Village, situated at survey number 168, IDA, Bolaram, Jinaram Mandal, Telangana. Out of the 200 kgs due to the urgency expressed by accused number 3, 100 kgs of the said product has been transported from Hyderabad to Mumbai via Pune in vehicle bearing number so and so, which was being driven by Koduru Sridhar and was intercepted by the officers of DRA Pune regional unit on 20 days. Upon testing with the help of the narcotic detection kit, that is the very same kit that has been taken. The product being transported in the said vehicle was found to be mitacoline, which is a psychotropic substance covered with the NDPS Act. Well, it's their petition, Maharaj may kindly see that they say this mere turning yellow in color is not a ground, it's mere suspension. So we kindly see.
Yes, I've seen that. Para 6 at page 14.
So, Maharaj, our contention is this, Maharaj. At the time of investigation, Maharaj, the kit that is before the officers, that is to be taken into consideration. That is the handbook that they have. And today they cannot claim, Maharaj, that the kit has turned into yellow color after the test conducted, but still it is not deciphered with a psychotropic substance. Maharaj, may kindly see the summons that is issued is under section 67 for the purpose of inquiry. They have not attended DRA Pune division till date, Maharaj. What they have attended is DRA Hyderabad.
Yes, we'll, yes.
But on the same day, Hyderabad premises where the manufacturing is taking place, where the raw material could also be seen. They have seized the remaining stock of 18 kgs. 100 kgs was transported, 18 kgs was seized. But I was also summoned to the office of Hyderabad. That's what I stated in the first petition, which my friend is.
Yes, when is the FSL report expected?
The report has not yet come even according to them.
Yes.
What I am saying is the present prayer, interim prayer is also heard. But if they want sign for it for finding something in secondary division, I can understand. We have not asked police send the sample of Hyderabad. Even Pune will also. But there are two tests for it. One is the qualitative, another one is the quantitative.
Yes.
It will be clear in the quantitative test. That is how I am making a request for a quantitative test to be a foolproof test. Let it be sent for it. I asked for alternative prayer. But the stock which has been seized and intercepted and seized in Pune can be sent for the quantitative test. Or alternatively, the stock which has been taken from the premises where it has been manufactured, admittedly, that can be sent in by prayer, alternative. And even according to their counter, the first matter, which my friend has referred to, it is a suspicion we wanted to investigate. Now that 5 people have been arrested, but including the person who was transporting and all that, but the apprehension has come true. But my submission is that my suspicion is based on the fact, because I've been examined on the same day, 23rd, the incident, 23rd August incident after intercepting has happened. On the same day, they've inspected my premises also. And I was summoned by the office of Hyderabad, I went there. So that is the reason why there is a basis for my apprehension. And your lordships have granted me protection, saying that no coercion will be taken.
Yes.
And thereafter, as the matter was directed to be posted here, I have not gone there. Later, I have not received summons. Twice I received summons, no doubt.
Yes.
But thereafter, no summons from Pune because probably report has not come.
Yes.
But I am asking for an interim prayer in this third item, saying that either send it for the quantitative test, not a qualitative test.
Both quantitative and quantitative tests.
When according to you, FSL report is
According to us, they said that it takes 15 days to get the report.
Yes, I'll order notice before admission and post it after 15 days. Let us await the.
With respect to the other petitions, we find a repeat petition. That's what IDC investigates. This is arising under the NDPS Act.
Yes.
Section 67 notice has been issued only for the purpose of an inquiry.
No, we'll await the FSL report till such time the stay will be extended. Yes, right.
The only problem that is arising is they are not even cooperating with the investigation, and in the meantime, the evidence is been tampered with. That is our case. But it's huge quantity, but that's what IDC this aspect. This is unlike any other offenses. This is a drug offense, where the commercial quantity is 500 grams. They have transported to the tune of 100 kgs. In such a gravity matter with respect to psychotropic substances, passing an order not to take court steps, infringing in the investigation. That's an awareness. Had it been any other offense of a criminal nature, it would not have been.
We'll await the FSL report and then we'll decide. Otherwise, you're opposing the passing of interim order in this writ petition. Yes, Rani? You cannot blow hot and cold at the same time. Heard the counsel for the petitioner. Heard the learned senior counsel, Mr. Prakash Reddy, appearing on behalf of the petitioner. Notice before admission. The learned counsel, appearing on behalf of the respondent, proposes the grant of booking order in the present petition 30819/2023 on the grounds that the FSL report is awaited. And the same with received within 15 days from today. That is before admission this time. 1st December. In petition number 24370/2023, the interim orders passed by this court on 3rd October 2023 shall stand extended to 5th December. This on 1st December, along with writ petition number 2019. List both the matters on 1st December. Interim order extended till 5th December. Yes.
Page number 3, item number 29, A. Prabhakar Rao, G. Praveen Kumar, Deputy Solicitor General of India, GP for Home.
Yes.
The license is valid up to 7/8/2020.
Yes.
Before the expiry of the document, the complete also requirements. While my application for network it almost not police just a letter. Just a letter to to renew the license on the ground the case is number 109 of is pending. Where my submission of HIGHCOURT in that tribe, where I am not a party, where I am seeking direction to the authority concerned by renewal application without reference to the letter address to the commissioner. Where I filed copy of the FIR, I filed copy of the remand report in which I was not recused. See that the petitioner is you are seeing as the stone crusher. And the other day, you are hearing you are the ground feeder and secondary ground feeder.
Yes.
But I write copies of the FIR remand report. I am not the accused. The entire
You're referring to crime number 109 of 2022?
Yes, sir. I am not the accused. I filed copy of the remand report. Remand report in the page. Page 44.
Yes.
42 is FIR. 44.
Yes.
The petitioner is toward the petitioner representing me, Rajan. Kindly see you. But the first of the Raju A1 is Atta Ramchandra Reddy, this abstanding. There is why just Atta Ramchandra Reddy, totally negative. Yes, forum Vijay. Anish. Then you have the A5, you have Kinnarao, P. Rajan, Bollaven Rajan, Nara Govind, Vodka Babu, Bolla Govind Spinning, and then you have Pasturi Raj, very something of Kerala is Nagar, Kerala, Angoli Raj. Then A16 is Island. The petitioner is Lord B. Rajan. But A16 blood statement, your A16 was arrested. And during the interrogation, he alleged that the A16 took my business and lease and we are supplied. But no paper has been filed. It's only confession. The last those who have the confession under section 24 of the Evidence Act.
Yes.
Except confession, no material has been placed before this armed court linking the petitioner with the said offense.
Petitioner is not even arrayed as accused.
Not even arrayed as accused. So that's exactly question was put to Milord. My friend Milord was certain whether he is accused or not.
Yes, what do you say? Yes. 15?
Yes.
Yes.
Surplus 1 and of the violations you also prompted by the judicial I read out for 1 year.
Yes.
At least of your exclusive mandate to unauthorized persons before the ILA.
You're reading page 15?
Page 50, second point surplus 1 to 8.
Yes.
At least of your exclusive mandate to unauthorized persons before the ILA. In a legal that violation of Rule 7 of the Explosive Rules 2008, and there is no provision to release of the explosive magazine, which is cross violation of 26 subclause 7 of Explosive Rules of 2008. Here, also we kindly turn to page 14. Rule 7 is extracted. What is the violation of Rule 7? Page 14.
Yes.
Right side here. Chapter 3, General Provisions. Rule 7. Control over manufacture, import, export, transport, possession to sale or use of explosives. No person shall manufacture, import, import, export, transport, possesses for sale, or use an explosive except as authorized or licensed under this rule. We are handing to the patient. Second point, another violation. The explosives were delivered unauthorizedly in violation of 10 of explosives, and unauthorized persons have transported explosives of different classes together in unlicensed vehicles illegally, posing threat to public safety and property in violation of Code 7, 10 subclause 3, 61, and 127 of explosives. The explosives of different classes are transported in unlicensed vehicles. This is in violation of 7, 61 of explosives in 2008. The explosion. These explosives were transported without having valid documents such as Form RE12, transport mass, and RE13. This is in violation of 24, 47, and 50 of explosives in 2008. For transaction of explosives, we have not followed due procedure as prescribed in explosives in 2008. This is in violation of 77 of explosives in 2008. Subject license is granted for possession and use of explosives as per Article 3C of Schedule 4, and it is not as per Article 3B of Schedule 4 of Explosives Code. Hence, this is a gross violation of protection granted in Form A. In view of the violations of Section 6A subclause B of Explosives Act 1884, in violation of 7, 10, subclause 3, 10, subclause 4, 24, 47, 15, 61, 77, and 127 of explosives in 2008, please show us within 21 days from the date of this letter as to why the subject matter should not be cancelled. We are watching to page 20. Page 12. So this is a letter issued by the Commissioner of Police, which is the last letter. On interrogation, the accused confessed that they procured the explosive materials illegally and not registered.
You're reading page?
12. Page 12. Page 12. This is the letter addressed to the licensing authority.
Letter issued to the Commissioner of Police.
Yes.
The response. Last paragraph. By interrogation, the accused confessed that they procured the above explosive materials illegally and unauthorizedly from cases of stone crushes mentioned in column number 5 of the application. However, the cases largely cited as accused number 15 could and a issue of Dr. Haseen and date 15. Focus notice we have mentioned this thing. Cited as accused number 16, and both they were arrested on 13 and 25, 2022. Respectively, the investigation is under progress to ascertain the complexity of either custody Sumaraswamy. Page 13, which is the form. Serial number 3, P. Lakshmi Stone Crusher. He is the petitioner, Your Worship. Originally, the license was given in the name of occupier and serial number 4, Your Worship, P. Rajayam. The license was allotted to P. Rajayam. He has unauthorizedly given license to lease Kunde Ilaya. It follows in the file. The tabular form.
Yes.
And the investigation reveals that the license for the above mentioned stone crushes was granted to the persons mentioned in column number 4 of the above table, but the license holders have given the said stone crushes to unauthorized persons mentioned in column number 5 of the above table for these, who in turn violated the rules and supplied the explosive materials to the anti-social elements and extremes. In view of the above circumstances, it is requested to cancel the licenses of the above 3 stone crushes with immediate effect for contravening the system and regulation of license. Thereafter, Your Worship can find it up. Page number 20. In pursuance of this renewal application, given a letter submit the documents on 25/7/2022. That is at page 20.
Yes.
With reference to the letter by dated 25/2022 from Commissioner of Police Karimnagar, informing to his office that crime has been registered against him, crime number of explosive substances Act 1908, section 10, 13, 16, 18 of the last act. Requesting in this office for cancellation of subject and his office shows notice dated 26/5/2022. You are advised to inform this office that the present status of crime number and any charge sheet has been filed against you in the court above crime. You are advised to rectify the mentioned point and submit the necessary documents for taking action. For this, he has not submitted any reply. Fairly covered by this.
Have you given a copy?
Page 2, your worship. Paragraph 5. Page 2, pattern.
Yes.
Petition hearing has submitted application dated 28/2022. Despite receiving and acknowledging the same, the second respondent either transferred the said application or rejected the alone comes to the petition of subject that has the first four of the case. Suspension of the license shall not debar the holder of the license from applying for the renewal, even the second respondent fails to consider the said application. The appeal filed by the petitioner challenging the suspension order was dismissed on erroneous consideration of crime. The respondents have not considered the appeal filed by the petitioner and also the orders passed by this court. Next paragraph. The respondents have filed on the stated that a crime was registered at the Kisra police station against the petitioner. There are serious allegations against the petitioner and it had violated the conditions of the act and also the rules. Therefore, a show cause notice dated 6/7/2019 was issued and an opportunity of being heard was given to the petitioner in terms of the common aid. The petitioner has submitted a representation to prove this suspension. A show cause notice dated 23/2022 was issued to the petitioner informing about the reported violations and requested to submit explanation. The petitioner hearing had submitted explanation reporting by the reviewer. By proceedings stated 15/1/2022. Second respondent has rejected the invocation. The suspension of the on the ground that the reported case was pending. The investigation officers have already filed charge sheet and to be lodged and para 8 last 4 days on the bottom. The request of the application for renewal of the license cannot be considered in view of the 112 subclause 8 of the petitioner having an opportunity of statutory appeal against the suspension order in terms of the Rule 121A of those rules. And your option para 10. It is not being discussed as per the 184 of the suspension of the license does not require license to operate for regulation. Therefore, the petitioner has submitted an application. So, second respondent for renewal of license. I don't know that government will deal with the renewal of license as per the government subclause 8 of the rule. Every license under this rule, other than a license granted for shall be renewed for a maximum period of 5 years. Where there has been no contravention of the act or rule, when there or any condition of the license for next year also. The remedy of appeal one is mentioned. And second one, the violation of these provisions and also the rules under the explicit. So his application was not done.
Where's other questions? The facts of the declaration does not make it justice. The declaration says to them, the petitioner therein was an recluse.
Yes, I've seen that.
Yes, no charge sheet has been filed against it. And the entire case of the prosecution built up on the basis of confession of the A16 and A15. The lawsuits are seen the counter also. In the counter, they proceeded to say that what's the kind of seen. The page 19 show cause notice given to me. Page 15. The case of the basis against me.
Page?
Page 20, my friend had read to me.
Page 20 of the counter?
Page 20 of the counter.
Yes.
With the reference to records that is the commissioner of this informing this body that crime is being registered against you. Me,
Actually incorrect.
Actually incorrect.
Explanation to that effect, your lordship. That was addressed on 21/7/2022. And today we did not submit any explanation whether crime is registered against him or investigation is still under process, you know, charge sheet is not yet.
I'm not even an accused therein. I'm not even an accused.
Yes.
First, my time is here. But page 12, I will read you. Second paragraph. The second paragraph. Again, I'm waiting for this. Interrogation that confessed that they approved and were legally allowed to complete lesser of stone versus mentioning alone by below. However, the lesser, how do we was in the area of psychology, both were understood as also disturbing. So this was the complexity of the this table is given as you are the I list out the premises. Now, paper has been filed. I'm not yet accused that a confession of a third party was written to. But the commissioner decides to get all the licenses cancelled. These are all the facts that the table has been prepared. As if the licenses were transferred. List out.
Yes.
And then there was address to the commissioner, the licensing authority for cancellation. Then I'm not yet accused. Ready. In fact, the entire case is on the basis of confession. The Supreme Court is passing case that is arises on the NDPA side. The three-bench judge has said, "Your confession is not admissible in evidence." Which section 24 of the evidence. I just read your section. But evidence.
Yes.
The confession to a police officer, not to be true. No confession made a police officer has been proved against the person accused of it. But this is the confession of blood A16. He says that I have taken the uses on lease on the basis of confession. That they proceeded and addressed a letter to the licensing authority to cancel the license.
Yes.
When I am not an accused in that case, the question of proving what the guilty against me does not arise. The last page 26 also. No confession made by any person while he is in custody of the police office unless he made the restriction towards unless it is made for the restriction. The 25 are allowed. On the basis of the confession of the other accused, not even
24 and 26.
Are the relevant to the confession of the accused in the custody of the police is not accusable in the rules, say cannot be used like this to prove the guilt unless it is recorded before the magistrate. But the judgment which has cited my friend, that is a case where the petitioner therein was an accused.
If the facts don't apply.
I'm only seeking. But still now license without reference to the word the vendor address will consider that is all. The agents for the community licensing authority to consider.
Yes. So 121 of the. Yes.
Appeal against an order of the or renewing a license or suspending or revoking a license of varying the conditions of the license. Okay, under section 121 the provision of appeal is not renewed. Case of non-renewal also appeal rights.
Sure, if we will obstruct and see, well, when the order is passed, that is an appeal bill. Otherwise, the no order is obstruction is pending there.
Renewed, in case if it is not renewed also.
So that's also.
Appeal under 121. So 109, it is not an exclusive trust, right? For 109, even for assuming you have the violation of so many rules and sections as per express act. And the license is already expired in the month of March 2022.
Yes. Anything further?
Before expiry of license, like submitted and one is pending for consideration, no orders were passed. The license consultant pass order without being under influence of the letter of the commission. That is all.
The documents which sought to be responsible. 20 image. On the 25/7/2022 motion, they were directed to submit such a document for custody. It is not in absence of motion, which was submitted an explanation on 25/7/2022.
Yes.
Submit explanation.
To submit whether the charge sheet has been filed. When I am no charge sheet is filed like this. Person of writing your any letter to them does not arise. Even though the Western Commission disclosure that I am not.
Yes.
Therefore, my submission was. Where third party statement, because I cannot be the penalized, but a confession statement of the third party, I cannot be penalized, but when I am not a party to the criminal proceedings, there is no obligation against me. I supply the witness to the accused therein.
Yes.
Well, they could have, but if there is a witness, what is will not wait, they could have notification as an accused. When the truth is there in the confession, learn the last part of the. When the behavior says they will have that super, they will connect to their licensing. They did not accept that there is no material, they did not say.
Yes. Yes. You're reading the proceeding stated? 21/5.
Instructions passed on by the.
Is 21/5/2022?
The written instructions is last page.
There is a tabular column. Which page? Yes.
No.
There's also supplies explosives to as per the request of Central, he arranged three safety wire budgets of the so it is clear. See, the Raja is running strong. Raja is the petitioner.
I just read.
They have brought in mouse and all in this.
That's also confession. That's also confession. Same thing which I read out in the demand report. It's also confession.
Granted renewal of license to Mr. Lakshmi Stone Crusher, the management shall be supplied the explosive material to respondent who in turn supplied to the banned Maoist party. Explosives for blasting and created panic situation in the mind of common people, which is dangerous to the general public and it may lead to major blind model person. This finding is also the same.
Last bit is also confession. The instruction is also based upon the confession. That even there is no evidence to show even A16 supplied. That's a matter that they inquired into the trial court whether it is applied or not. That's what the last paragraph. In this case, as per the confession of A16 is uncle. Only Rajaya, resident of village, he is exposed to leader, he has exposed to magazine, storage of place, he has leased out the magazine. When he says leased out the magazine, what is the basis for to say that is leased out? There no paper has been put. On basis of confession, they proceed to pick up case. The fact remains whether A15, A16 applied or not is an issue before the trial court in trial number 109. Even after this, also I was not made a request. Had it been made a request, I would have filed a petition for seeking punishment of mistakes.
Yes. Yes, right.
And only to consider my application. The application is rejected and final. My application is still pending. When I am only seeking the direction of this time. Consider my application without reference.
Reference to the letter of the commissioner.
Commissioner report says only on the basis of confession.
We'll dispose it off directly. Without going into the merits, we'll dispose it off, directing them to pass orders on the application. Without reference to the commissioner's letter, taking into consideration the fact that he is not arrayed as an accused in the case. Friend. Counsel to the petitioner. The learned counsel appearing on behalf of the respondent. The petitioner approached the court, seeking prayer and under. The learned counsel petitioner specifically brings to the notice of the court that the petitioner is not an accused. Crime number 109/2022. Even according to the respondents, but however, based on the letter of the commissioner, dated 21/5/2022, page 12 of the counter, addressed to the German Chief Controller of Explosives. 64 CGO towards Kavadi. Application of the petitioner seeking application 4 weeks. Yes.
Page number 5, item number 52, Chandrasen in office, D. Praveen Kumar, Deputy Solicitor General of India, K.R. Koteshwar Rao.
Yes. Yes. Page.
This by was to kindly consolidate the paper. Petition counter and repair. Paper.
Yes.
The page to stay. Page 30.
30.
Page 13.
Yes.
It is dated 10th April 2023. Notice for a vacation of premises of bungalow number 207. This bungalow number 207 was purchased way back in the year 1965. The registered secretary, there is no dispute in regard to the same. Now, motion by Chair Context. In his connection, petition 2.28 of 2003, filed before the Honorable dismissed on merits. And there we will also find a suit in verse 676 of 1998. The same was dismissed, appeal was dismissed, and second appeal was also dismissed. In this regard, you will be hereby directed to vacate the said premises within 3 days of the date of receipt of the in which marriage will be issued. But the genesis of this letter is order dated that will be 2.28 of 2003. Lordship may see that 2.28. Page 6.
Yes.
Counter and method.
Yes, I got it. Yes.
As per the information registry, the expedition is pending. But however, the bundle was not contained for permission is offered to reconstruct the bundle.
You are referring to 54 of the compilation.
Yes, sir. Compilation. I not see the blue color.
Blue color is
right side blue color.
Yes.
WP 2.28 of 2003.
Yes, it's the order.
Yes.
We should go by the blue.
Yes. Well,
yes.
As per the information published by the registry, the petition is pending. However, bundle is not available. Therefore, permission is offered to reconstruct the bundle. Particularly, this quotation law that some published also. Despite listing the matter under the caption of others, even today there is no representation on the petitioners. Quotation of letter processes also. Further of the record revealed that the petitioner has submitted a representation dated 23/1/2003 with the respondents to regularize the compound wall of unauthorized structure sources also and having been rejected. Subject line is B3. So, my lord, may I kindly go to the next paragraph. Based on the said facts, my lord, may I kindly go to paragraph 2. The upper said fact revealed that the respondents have rejected the representation dated 23/1/2003, proceeding dated also. Therefore, there is no error in it. In view of the upper said discussion, the petitioners are paid to make out any case of interference. The said proceedings filed with the respondent. However, in this, the main genesis of the dispute which arose in the waiver in the 2003 is a letter dated 23/1/2003. The Lordship may kindly go to the letter dated 23/1/2003 to the page 130.
Kindly see page 130.
Yes.
31. The issue is regularization of compound wall of unauthorized structure. A representation was given based on the orders of the order lines. The second paragraph.
Yes.
We are ready and willing to, for compounding the structures as per the terms you may impose. Under section 185 of the Act, we have a right to claim the benefit of compounding of unauthorized structures. We are ready and willing to pay the necessary amount which may be charged towards the regularization fees. Thus, we are applying for the benefit of compounding service. We therefore request you to consider for request for compounding unauthorized structures. This was issued way back on 23rd January 2003, and this representation was decided by the Honorable High Court, which I showed to the Lordship page 54. But the fact remains is that in the petition where the Honorable Justice Lakshman has disposed of, there the council is some other council, we are not appearing. But the fact remains is that the containment court has suppressed the facts. My Lord may kindly see. Kindly turn to page 17. There is a judgment and decree in favor of the petitioner. That was suppressed.
Page
17. OS 75 of 2003, dated 31st December 2014.
Yes.
31st December 2014. Lordship may kindly notice the first title, the petitioners, the petitioner mother, and Union of India Containment Board. This is a contested school. They are not experting, they are contested trial issues were framed. Now, my Lord may turn to the issues. It's on page 37. Page 37.
Yes.
Whether the plaintiffs are absolute owners of the principal property, whether the school property is owned by government of India, whether the classification of JLR 1956, the suit land is an old land, otherwise not binding on the plaintiff, whether the suit is granted in law for not giving prior notice of the section 270 of Containment Act, whether the plaintiffs are entitled for a declaration, the principal property is free from me, the plaintiffs are entitled for a grant of permanent injunction, and to what degree. Now, my Lord may actually turn to the decision, page 52.
Yes.
In the result, in view of the court finding on issue number 1 to 6, this court has to oppose the defendants for regularization of the possession and enjoyment of the social property and the structure thereof. All such approach by the plaintiff, the second defendant, in exercise under section 240 of Containment Act within a reasonable time, defendants not to evict the plaintiff without resorting to the due process, as the injunction is granted in favor of the plaintiffs while answering issue number 6. The suit is decreed in part, and each party is to bear the own cost. This fact was suppressed before the Honorable High Court, before the 15th Court for us. We filed a review petition. The Containment Board was aware about this fact. No appeal is filed. This has become final. Now, my Lord, pursuant to this, the Lordship may kindly turn to the representation. There is a direction that the petitioner should approach the Containment Board by giving representation. The Lordship may kindly see page 134. 268. 268.
Yes.
Dated 13/12/2016. This is with reference to the court family court order in invoice number 75/2003. The above suit has been decreed in our favor Honorable Judge has asked us to approach you for regularization. We had immediately approached your office for regularization. However, your office has informed us that you are not, we are going and appeal. Please note that there is no stay against us by any court approaching you for regularization. Hence, we request you to kindly regularize the construction as per the direction of the court. Please note that all necessary documents have already been submitted in OS number 75/2003, which are available with you in your office. However, in case you require any additional document, please let us know. We are enclosing the copy of the degree. Enclosed. The Lord may see on the top of it. This was received by them by the number 11686 dated 13/12/2016.
Yes.
At the top of it. They did not challenge the degree as on this date, and they did not take any decision on this date. In spite of that, they issued the impute notice. But I filed a petition specifically stating, the Lord may kindly go to the affidavit manner.
Page.
Affidavit is parallel. Parallel page 10.
Yes.
It is submitted that in pursuance of the judgment and decree, the petitioner has made a representation dated 13/12/2016, and the same is pending for consideration. It has been specifically pleaded. In the counter, they say that no such representation was given. No such plea was taken. But I never expected the cantonment board will come out with a plea. They have stated that as per the record, there is no such letter in existence. My lords have directed them to produce the registry. But what they did, they produced the registry. Your lordship had directed my friend to give a copy to us so that we can also submit. They filed additional count of now. They said they produce on that day. Now they're telling that is missing. But how can I understand this type of a behavior to containment board? A judgment is in my favor. Letter is that this is everything is valid and everything. Now they say that this is missing. Additional counter is filed on October 9th, 2023. This type of plea
Additional comment.
is to get the suspicion. Just to get trouble the petitioner, keep on lying and lying.
The additional counter extra copy is there. It appears.
Not interesting. 9th October 2023. And pass on the copy.
Yes. Para 5 of the count of the dispute that they have not received it.
Yes, ma'am. Okay, at that time, they produce some document. This also, they can put a blame on.
Here the plea. Here the plea taken is if you have not received the representation. The counter affidavit para 5.
They are not required. You are absent today with no such representation available. Inside involved the register is also missing here, so as the representation.
That is a purely negligence of the petitioner. There is a judgment and decree in fact. There is an objection.
There is a objection. The petitioner and some of the lower.
There are thousands of properties of the containment. Everything they put to our blame because the
Figment of imagination, we have stated for the sample. It is not available, even the register is not available.
Even otherwise, the additional affidavit says that it is defective.
Defective. Defective also is allowed, but they should. Clearly, I never expected containment code will scoop up this level. Well, I have a degree, they did not challenge the constraint degree. That constitute words are not used. And I suggested that no interpretation that they can be disposed of beyond 3 presentations. All the representations submitted by them. And where is the what is the exact parameter to dispose of this representation also? Absolute nothing. The document is not with us, it's with the person disclosure. Even that representation is covering only 500 square yards of land, where the entire extent is 100,000 square yards, wherein cluster buildings have been constructed.
Initial date of interim order is?
On 13/1/2020 initially, extended on the 8/6/2020. Now, whether your lordship may see my friend was telling, kindly try to 228 minutes.
Page
228.
Yes.
This is dated 20th June 1998. Whereas it is considered that the erection and re-erection of the building specified in the schedule below. So constitute an offence under section 184 of Containment Act. Now, therefore, in exercise of the power conferred in subsection 7, so the building should be stopped, erected, created. That's it, matter. Allot may see the schedule. Bungalow number 207, Sikh village, list of the measurements of unauthorized constructions, so and so. The lordship says ground floor 1 by 47 feet into 48 feet.
Yes.
RCC. The total extent all put together is constructed in over extent of 500 square yards only. Front portion. Now, when under these guys, they want to attack the entire premises, which is about like or more than. This is the first letter which is issued.
Anyways, now by way of an additional affidavit, it is pointed out that the representation made by you is defective. The representation dated 13th December.
They are unable to trace out.
They also say that it is defective. Kindly see the additional page 4.
Let them choose the one whether it is fabricated or a defective. If they are defective, then they are going into the merits of the case. Let them issue watercolors in our favor. Let them reply to the. I have a judgmental degree. Based on the judgmental degree, I gave a representation. Now, first they say that it is.
Page 4, the first paragraph. Page 4, the first paragraph says that the representation dated 13 December 2016. No details have been furnished. Hence, the application is defective. Even to look into that aspect or forwarding the same to the defense estate officer for his consideration as per the statute.
They should have issued for any clarification. I mentioned suit number. The lordship may see the representation. Kindly go back to. $268. 268.
Yes.
This is with reference to the Court of Justice. So in OS number 75/2003, I have enclosed the copy of the judgment. Well, how can the appropriate and implement balance? In case you require any additional document, please let us know. We are enclosing the copy of the FO decree.
What is the difficulty? You give a fresh representation, giving all the details within 2 weeks from today. and let them consider it within a period of 2 weeks thereafter. In such time, no coercive steps in pursuant to the letter dated 10th April. No, your additional counter affidavit said that you could not act upon that because it is defective. Yes.
Even the stock registered as well as.
Yes, we'll not go into that now. However, your additional counter affidavit. Yes.
Even representation is covering only restricted standards.
He will give it.
That particular, whatever legal constructions that were made for a certain penalty by a civil suit, first appeal, second appeal, by this honorable court. And even what the conduct of the parties are also highlighted by this honorable court. Because in spite of an order passed by the court, not to present the construction, they have proceeded with proceedings are initiated against them.
Yes.
And they were penalized for raising such constructing various court orders. But even his lordship Lakshmi also passed an order saying that whatever representation that was disposed of in 2003, that order was, his lordship said that the speaking order passed to the contempt court doesn't have any legal infirmity. So far as this particular application of 2013 is only pertaining to finite experience lots. But that cannot be extended to entire structures made in the suit in the bungalow property of 2200 square yard, 20,000 square yard. Lakshmi kindly just observe if at all that need to be considered, the representation, that should be confined to only 500 square yards as per the decree passed in the OS number 75.
He'll confine to the decree only. Please. Kindly look into the additional affidavit. You have a copy or you passed on to the court? Your own additional. Kindly, we'll not go into that. Kindly go the last line. The last line of the additional counter affidavit filed by respondent number 2. Last line at page 3. Petitioner has not. Yes, the entire paragraph. We are not going into all that. Yes, entire paragraph. Kindly see that it is clearly pointed out by you that you read that. You have the copy? Yes. Page 4. Yeah, page. Additional counter. The first paragraph. Counter top, additional counter affidavit, page 4, top. Yes.
Yes, I clearly mentioned that directed to 500 square yards of land, notice and furnished as to how many court are constructed.
Yes, kindly read further. Yes.
Constructed and what is the site utilized, and these details are to be drawn in a plan and clear-cut measurements from the certified architect to the shape should be enclosed with the representation to the court for consideration. But the respondent so.
But in the representation.
Details are furnished.
But in the representation dated.
Yes, except the representation, he has not given any measurements.
Further.
No, that's good. And the application is defective so as to look into that aspect for forwarding the same to the district officer for his consideration.
As per
I mentioned this aspect in lordship. In 2004, Honorable Supreme Court, but in case of this issue was already in case of Lord Mohammed Moinuddin versus December 2004, the Honorable Apex Court has not paragraph 17. The property is classified as a deeply old land, and the property rights vested in the Union of India. The Cantonment Board and the Defense Officer has every right to present such application for compounding the illegal constructions made on Bangla property lots.
You take a decision. We are not at this stage now. You have pointed out in your own affidavit filed By way of a counter affidavits, you have pointed out certain defects. And for this reason, it could not be forwarded to the estate officer for estate officer to act as per statute. Rectifying all those, a detailed representation will be placed before you, confining to the order of the lower court, the decree and the judgment of the lower court. Consider and pass orders within 2 weeks thereafter.
Yes.
Yes.
To the extent of decree, 500 square.
To the extent of decree.
Degree, why certain?
We are not going into the merits, we are not going into the rival contentions, we'll only simply.
Can also give opportunity.
Yes.
So you return the opinion in person.
And then decide the issue. Till such time, the impugned order would be stayed.
Once with regard to that aspect.
Only with regard to?
500 square.
Only with as per the decree, I'll observe. Clearly observe as per the.
But this one, I made an official first day, first instance, I made a did not accept.
Yes. Keeping it pending unnecessarily. Yes, right. The petitioner approached the checking prayer as in the extract the prayer. initiate any coercive steps in pursuance to the letter dated 10th April 2023. Yes. Yes. As I have said that. Yes.